Advocate Piccolo, you are reminded that you are still under your former oath.
Yes, Chairperson. Thank you.
Thank you. Mr. Vani.
Thank you, Chairperson. Thank you, Commissioners. Mr. Piccolo, yesterday the last point that we dealt with was a reflection on the NPA annual report of 2005 and 2006. And I want to refer you to a presentation made by the NPA to the Justice Portfolio Committee on the 8th of March 2006. And it's in your bundle, it's bundle 2 at page 110. I just wish to check, Commissioners, can I be heard loudly and clearly?
Yes, you are loud and clear.
No, I will try to lean over these mics.
Yes, Abdul.
Okay, so we're at bundle 10, it is bundle 2, page 110, and it's titled NSSD Report to Portfolio Committee by Dr. Silas Ramaite, SC, and those present include from the SCCU, Advocate Jordan, from the WPU, somebody by the name of D. Adam, from SOCA, Advocate T. Machakweni, and the PCLU, Advocate Ackerman, and it's dated actually 8 March of 2006. And if we turn the page, there's a slide presentation made by Advocate Ackerman of the PCLU, and then on page 112, there's a slide dealing with performance against targets for the financial year 2004/2005. And there he puts up some bullet points. TRC prosecutions, audit of 300 cases, closure of 167 cases, prosecutions instituted in Terra Blanche, Blani, and Nivat, which we have discussed yesterday. And then I want to focus on that bullet point that says further prosecutions put on hold in November 2004, pending the formulation of guidelines. And if we could just turn the page to 113, the title is Performance Against Targets for the year 2005/2006. Under the heading TRC prosecutions, failure to finalize guidelines results in no further prosecutions being instituted. So you testified yesterday that you were not aware of the what one can term a moratorium that had been placed on the TRC cases pending the issuing of the guidelines. But am I right in saying that at least by this time, so we're talking March of 2006, given the slides that further prosecutions put on hold in November 2004, that it had come to your attention?
Good morning, Commissioners. Yes, that is correct.
Then let's move on. Yesterday, you testified that you gave an instruction to the PCLU to go ahead with the prosecution in the matter of the attempted murder of Frank Jucani. And if I can refer you to your bundle, and indeed your 2015 affidavit, that's at page 10, paragraph 27.
Page?
So it's paginated page 10.
Yes.
And if I can draw attention to paragraph 27, and could you read into the record, please, in your loud booming voice, from paragraphs 27 to paragraphs 29.
Thank you, Commissioners. Paragraph 27 reads thus. When the prosecution policy became effective in December 2005, I reviewed the available evidence implicating the 3 suspects in the Jucani matter, which, in my opinion, was clearly sufficient to justify a prosecution. None had applied for amnesty for this offense. I therefore gave the initial instruction to proceed with the prosecution in February 2006.
And can you read till the end of paragraph 29?
Paragraph 28.
Yes.
In response to the said notification, the 3 suspects made representations to me in terms of the guidelines in support of their contention that they should not be subject to prosecution. These representations were reviewed by a team within the National Prosecuting Authority under the leadership of Advocate T. Pretorius, who reported to me that the representations did not comply with the requirements set out in the guidelines, insofar as the suspects declined to disclose the full truth. After reviewing the report and the underlying documentation, I wrote to the legal representative of the suspects in July 2006, informing him of my intention not to accede to the representations and to pursue the prosecution. Paragraph 29. Meanwhile, in early 2006, I had approached the then Commissioner of Police, the DG of Justice, and the heads of the NIA and the DSO, also known as the Scorpions, requesting them to nominate senior officials to assist the PCLU in accordance with the prosecution policy guidelines. Unfortunately, the SAPS and the NIA never provided the PCLU with the necessary support to conduct its investigations adequately.
And Mr. Pikuli, I suppose the lack of investigative support is really the nub of the matter. And without investigation officers, am I right in saying these cases, the ones that had not been investigated, could not proceed?
That is correct, Commissioners. And then also, if I may add,
Please.
what I said in paragraph 28, in terms of any accused person making representations to the NPA, it's a matter which has already been there. Therefore, the guidelines or the amended prosecution policy didn't make any difference, because that has always been there, that any accused person can make representations to the National Director of Public Prosecutions. Thank you.
Thank you. And on the question of investigative support, I just want to put to you paragraphs from the affidavit of Anton Ackerman and Commissioners and Mr. Pikuli. That's in bundle 3, B3, at page 12. Do you have bundle 3?
No, I've got 2 bundles.
We'll just get you that bundle quickly. And if you can get to page 12 of bundle 3, please, Sipa.
Thank you.
So that is the affidavit of Advocate Ackerman, which he also made out in 2015. And he says at paragraph 26, I'm going to put paragraphs 26 and 27 to you and seek your response. In March 2006, I again met with the representatives of the Simelane family. I had to advise them that I was unable, as there were no investigators attached to the PCLU. Requests I had made to the SAP and the DSO for competent and experienced investigators in this matter and the other TRC cases had fallen on deaf ears. The said representatives also supplied me with a legal opinion that's dealing with the crime of torture under international law, so I'm going to skip that. To paragraph 27. As a result of this meeting, the said representatives wrote to the then NDPP, Advocate Pakoli, requesting him to reach out to the SAPS and the DSO in order to secure competent investigators for the PCLU as a matter of urgency. These efforts were not successful, and then he advises the representatives to rather pursue an inquest. So, according to Anton Ackerman, they were so constrained around this time. Do you recall getting a request from the families asking you to reach out to SAPS to procure investigators?
Yes, Commissioners.
And did you take any steps thereafter?
Yesterday, I did make a reference to this, that there was this toing and froing on the question of availing investigators to assist the PCLU in conducting the necessary investigations before a decision could be taken whether to prosecute or not to prosecute on those matters. So I spent the last part of my time trying to convince the National Commissioner. I think somewhere, in these bundles, we'll be able to find that I even wrote letters to the National Commissioner, to the DG of Justice, DG of NIA, asking them to cooperate in terms of, assisting the process go forward.
And we will get to that documentation in due course.
Yes.
If we can continue with your affidavit, so back to bundle 2. And we're now on page 11. If you could read into the record paragraphs 30 and 31.
Thank you, Commissioners. Paragraph 30 reads thus. In early 2006, the then Commissioner of Police, Mr. J. Silibe, objected to Advocate Ackerman's participation, claiming that Ackerman intended to prosecute the leadership of the ANC. This is notwithstanding the formal denial by the NPA that no such plans were in place. I advised Mr. Silibe that Ackerman was appointed as the head of the PCLU under presidential proclamation, and it was not for the SAPS to determine who should discharge the mandate given to the PCLU. Paragraph 31. I then approached the Presidency in order to secure the necessary collaboration of the parties to apply the prosecution policy guidelines. A meeting was arranged in mid-2006 by Reverend Frank Jucani, the then Director General in the Presidency. The meeting was attended by himself, the DGs of Justice and the NIA, Mr. Silibi, the Secretary of the Defense Secretariat, Mr. Jafta from the Presidency, and I. Mr. Silibi again complained about Advocate Ackerman's involvement in the process. Thank you, Commissioners.
Thank you, Mr. Bekuli. So, at that meeting, you said it was called to facilitate the collaboration of the parties to apply the prosecution policy guidelines. At the conclusion of that meeting, did you think that collaboration was going to be achieved?
Thank you, Commissioners. It was clear that for as long as Mr. Silibe objected to Mr. Ackerman participating in the process, that it was going to be really, really difficult to be able to get what I was trying to seek from the DGs. Because it's a matter which kept on coming up, Ackerman, 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 all the time. Thank you. Now,
Mr. Bekuli, you made out a very comprehensive affidavit to the Jinwala Commission of Inquiry, which was set up by President Mbeki to inquire into your fitness to hold office. And that affidavit was made out in 2008, so not long after all these developments. So I think we would want to rely heavily on that affidavit. And if I may refer you to the extracts dealing with the TRC cases that have been attached to Bundle 2 at page 139 of your current bundle.
of my bank, 139.
139, yeah. Do you see the extracts from the affidavit that you made? So it's bundle 2.
Yes, I'm there.
Okay. Now, can I ask you to read into the record from paragraph 267 to 275. There will be a little bit of repetition here, but I don't think that is a problem. So that'll be paragraph 267 on page 139.
On page 129.
39.
139, Advocate
Okay.
Bekuli.
The Tenants Commission.
So paragraphs 267 to 275.
I think I'm having a problem here. This is bundle 2. And I started looking at here, 139, which is bundle 1.
No, you need to be in bundle 2.
Yes.
Yes.
Then I must go back to, yes, bundle 2, 139.
Yeah.
And I'm on 139. And I don't have 263.
Okay, we'll just, it's 26, it's paragraph 267.
267.
Yeah.
Okay. That's on.
You have that?
Yeah, that's correct then. It's
Okay.
on 139. 267.
Yes, so, yeah, paragraph 267 to 275, please.
Okay. Commissioners, this is how this reads. I'll read it into the record. In January 2006, I wrote letters to Mr. Silibi and the DGs of Justice and the NIA and to the DSO, requesting them to nominate a senior official to assist the PCLU in accordance with the prosecution policy guidelines. 268, almost from inception, the process was bedeviled by the failure of SAPS to provide the necessary support to enable the PCLU to conduct its investigations. These difficulties are dealt with in paragraph 4 of TRC 1. Paragraph 269. I was advised by Mr. Silibi that Advocate Ackerman should not participate in the process. The distrust between SAPS and Advocate Ackerman stemmed from allegations and counter-allegations in regard to the latter's supposed intention to launch criminal proceedings against the leadership of the ANC. These contentions had surfaced from time to time, notwithstanding the issue of a press release by the NPA in 2004, confirming that a decision had been taken that no such prosecution would take place. A reference to Annexure TRC 2. Should I proceed?
Yes, all the way to 275.
Okay. Paragraph 270. I informed Mr. Silibi that Advocate Ackerman was the head of the PCLU by presidential proclamation and that it was, or that he was appointed, that it was, I think there's a mistake here, writing, but it was not for SAPS to determine who should discharge the mandate given to the PCLU under the guidelines. Paragraph 271. Faced with this lack of cooperation, I sought the assistance of the Presidency in securing the collaboration necessary to apply the prosecution policy guidelines. Paragraph 272. In mid-2006, Reverend Jucani organized a meeting at the Presidency, which was attended by himself, the DG of Justice, the NIA, Mr. Silibi, the Secretary of the Defense Secretariat, Mr. Jafta from the Presidency, and I. This first meeting dealt in general terms with the question of developing a spirit of cooperation amongst the agencies as contemplated in the guideline process. Reverend Jucani supported the notion that there should be collaboration in assisting the NPA to fulfill its functions. At this meeting, there was again a complaint by Mr. Silibe in regard to Advocate Ackerman's involvement in the process. My recollection is that there was no discussion of the information of a working committee at this meeting. Paragraph 273. Some time later, a meeting was convened at the home of Minister Square, the Minister of Social Development. The meeting was attended by the Ministers of Safety and Security and Defense, Minister Toko Didiza, Acting Minister of Justice and Constitutional Development, representing Minister Mabandla, who was indisposed, and Mr. Jafta. The meeting was called by Acting Minister Didiza, and I was told that it related to the prosecution in the Jucani matter. It was originally suggested that Advocate Ackerman accompany me to the meeting, but I elected to go on my own in order to establish what the concerns were. Paragraph 274. It transpired at the meeting that, and then there are several subsections, 274.1. The Minister of Safety and Security was concerned about the decision to proceed with the prosecution and with Advocate Ackerman's involvement in the process, and the issue of whether it was Advocate Ackerman or me who was behind the decision to prosecute. 274.2. The Minister of Social Development was concerned about the impact of the decision to prosecute on the ranks of the ANC cadres who were worried that a decision to prosecute in the Jucani matter would then give rise to a call for prosecution of the ANC cadres themselves arising out of their activities pre-1994. Paragraph 274.3. The Minister of Defense had concerns about where the decision to prosecute rested. Did it rest with me or did it rest with Advocate Ackerman? Paragraph 275. I explained to the ministers that the decision to proceed with the prosecution rested with me, as did all other decisions in regard to post-TRC prosecutions being considered by the PCLU. I assured them that no prosecution would be undertaken without my specific direction and reiterated my concern about the delay in the process, particularly in view of the requirement that I report to Parliament on these matters. My recollection is that there was no discussion about the formation of a working group or task team at this meeting. The Minister of Defense appeared satisfied with my explanation that I would exercise the decision as to whether there was a prosecution or not. The Minister of Safety and Security appeared to continue to be worried about the involvement of Advocate Ackerman. I have no recollection of a particular position taken by the acting Minister of Justice.
Thank you, Mr. Picoli. So let's just deal with this meeting that took place at the home of Minister Squiggia, the then Minister of Social Development. Do you agree that it's quite an extraordinary development that you are called to a meeting at the home of a cabinet minister, and there you are confronted by several other cabinet ministers who proceed to question you about a prosecution in a particular case? Is that not an extraordinary development in your view?
Commissioners, no. It didn't take me by surprise. But in fact, I saw it as a way of continuing stating our case insofar as the lack of cooperation from other departments. Because by this time, we already had the guidelines and the amended prosecution policy. Now we were to follow clearly those guidelines and the amended policy. So I felt that it's now actually an escalation. I was hoping then out of that meeting, they will be able to give instructions to their DGs that they must work closely with the NPA. But what I did not allow in that meeting, because they had also called Anton Ackerman. They wanted him to be in that meeting. I felt no need to involve Anton Ackerman in that meeting because I am heading the NPA and the responsibility is on my shoulders as the head of the NPA. So I felt that I had to protect my prosecutors from direct interaction with members of the executive. My interaction with members of the executive, I didn't see any problem with that.
But Advocate Picoli, was it normal practice for cabinet ministers to call meetings at their homes to discuss issues they had with the NPA?
This was the first time that it was happening, but also one, taking into account the context, the broader context. And again, yesterday, I'm hesitant to repeat that we were dealing with a situation that we have never dealt with before. And as I said, I was prepared to cooperate as far as I could go, but there was a line that I had drawn.
Thank you.
Just there, I conflict in my own mind, I don't know why. The duties of Minister of Correctional Services and the presence of Minister Squia, that would be Minister Zola Squia, the late Minister Zola Squia. Why was he there?
Are you asking about the Minister of Correctional Services?
Yes.
No, I have no recollection of the Minister of Correctional Services being in that meeting.
No.
The meeting, I'm sorry, Commissioner.
Minister Zola Squia,
Yes.
the Minister of Social Development.
Yes.
The relevance of his presence at that meeting.
Yes. Yesterday, when I was explaining the minister's cluster as well as the DG's cluster, the composition of the JCPS cluster included the Minister of Social Development. But then I further on to explain the entire criminal justice value chain. Police, prosecutions, the court, correctional services, and social development in terms now of those members or the offenders who would have been rehabilitated by going through the process of corrections would need to be reintegrated back into society as good members of the society. Then that would explain the involvement of the Department of Social Development.
Yes. Thank you very much for dispelling my misconception. Thank you.
Thank you, Commissioner.
At that meeting, I take it that everybody was fully aware of that your decision to prosecute had already been taken.
That decision had already been taken. Because
Were they aware of that?
I would think so, that they were aware.
And that's why they were raising concerns.
Yes, as to the possible impact or consequences
Yes.
of that decision. Thank you, Commissioners.
Thank you, Commissioners. Just on this meeting, it was held at the home of Minister Squia. It wasn't held in a government office. Do you remember at approximately what time it was held?
I think it was perhaps late afternoon towards early evening.
Right.
Yeah.
So already this is unusual because it's being held, if it's early evening, we're talking after hours. And it's not being held in a government office, it's being held at the home of one of the cabinet ministers. And I want to follow up on the chairperson's question to you. The previous meeting you spoke about in paragraph 272, that was specifically called to look at how cooperation could be secured to implement the guidelines. But in relation to this meeting, that didn't seem to be the case. And if I can refer you to your paragraph 273, third line, the meeting was called by Acting Minister Didiza, and I was told it related to the prosecution in the Jucani matter. So this particular meeting was called by those cabinet ministers to discuss a specific case. That seems to be the case.
That is correct, Commissioners.
And so that's why I posed the question: is it not extraordinary and perhaps even improper for cabinet ministers to be calling in the NDPP? And of course, it does seem as if you were called in cold, but improper on their part to question you about a specific case that you wish to prosecute?
Thank you, Commissioners. My approach was always that of tactical flexibility, if I may say, without compromising the independence of the NPA. As part of exercising that, tactical flexibility, I felt that, as a demonstration of my willingness to collaborate, to cooperate, that I didn't feel that at a personal level, I don't know another, perhaps NTPP, but I didn't feel at a personal level sort of scared to have an open discussion with members of the executive around these issues.
Yes. No, it's clear that you stood your ground,
I-
correctly so, but we're now talking about the conduct of the ministers in calling that meeting in the first place.
Yeah, well, yes, somebody can make that call and say it was improper because we're dealing here with issues of state, therefore issues, firstly, meetings should be, in government buildings or state institutions at appropriate times, but we're dealing with a matter, that was not, your run-of-the-mill matter. That's why I felt, let me demonstrate my willingness to cooperate. You see, my approach to the independence of the NPA is not a rabid obsession with independence, to the extent that I wouldn't allow issues of accountability, reporting on the work of the NPA, because you know that Section 35 of the NPA Act makes reference to the fact that the NPA is accountable to Parliament. Therefore, there had to be interaction between the NTPP and the executive. It's in the Constitution itself, the formulation of the prosecution policy, though in the main it is for the NTPP to determine, meaning that the NTPP acting alone with his or her directors of public prosecutions must determine the policy, but with the concurrence of the minister responsible for the administration of justice.
If I could come in there, Reverend Frank Jucani is known to be fiercely independent and principled, but was it not putting him on the spot, to use one of your words yesterday, for him to be present? Should he not have been excused? It seems there is some measure of him having an interest in that matter. Was he not asked to excuse himself or ask whether he should be excused?
Thank you, Commissioner. Perhaps a fair point to make, but at the same time, even when you can be affected by certain things, but also it is a responsibility that is on your shoulders. By virtue of being the DG in the presidency, as DGs, we regarded him as the DG of DGs, in terms of ensuring cooperation and coordination of the work of government. Therefore, he had this responsibility. The question of availing investigators, did not necessarily mean that he was going to be part of that. But also, Commissioner, you will recall that there was also this insistence coming from the National Commissioner of Police at the time, who kept on saying that we can't go ahead because Reverend Jucani has not been consulted on this matter, which was far from the truth. I take your point, but also I'm saying somehow the matter had to be escalated, and the beginning of such an escalation had to start with the DG in the presidency, just to facilitate the cooperation. Because there, I raised that matter with him because of lack of cooperation.
Yes, in any event, it was not your call to make for Reverend Jucani to perhaps excuse himself as being somewhat conflicted. But thank you very much.
Advocate Piccoli, am I understanding your evidence correctly that at the meeting convened at the home of Minister Squia, Reverend Jucani was not present?
No. You are right, Chairperson.
Yes.
Thank you, Chairperson. At that meeting at the home of Minister Squia, you also referred to the Ministers of Safety and Security and Defence. Can you just identify them?
The Minister of Safety and Security at the time was Mr. Charles Ngakula, and the Minister of Defence at the time, may his soul rest in peace, was Mr. Terra Likota. And there was an acting Minister of Justice, Ms. Toko Didiza. Yeah. Those, yeah, I think it was those ministers.
Great, thank you.
Were they?
And can we revisit your paragraph 274.2? That's on page 142. And there you see the Minister of Social Development. According to you, he was concerned about the impact of the decision to prosecute on the ranks of ANC cadres who were worried the decision to prosecute security branch members in the Jucani matter would then give rise to a call for the prosecution of ANC cadres themselves, arising out of their activities pre-1994. So my question, Mr. Piccoli, in your view, is that the reason that those ministers were so concerned about the Jucani matter going ahead, and needless to say, other TRC matters as well?
Yes, taking everything in context, the context being king in trying to have an understanding of issues, whether simple or complex. Yes, given the fact that the then National Commissioner kept on saying that there's this sinister motive at the NPA, which started during the term or tenure of my predecessor, was that the insistence on the part of the NPA to go ahead with these prosecutions is because they also want to prosecute President Mbeki and other ANC leaders, whether in government or outside of government. So this is what has always been dangled as some kind of a threat or a risk which might actualize or realize once there's just a prosecution, particularly against former police officers. So this is what was always there, being dangled as a threat, because there was this organization led by General van der Merwe, who was the last National Commissioner of Police prior to 1994, that he had a group of people, and there were some people working with him, assisting, building a case in terms of evidence that they had as the then SAP ready to prosecute ANC members. That was the reality. So I always saw the Jucani case as a test case, basically. You know, that things will stand or fall by the decision taken by the NPA on this matter. That was how I saw things unraveling.
So, if one has to look for an underlying motivation, would it in fact be this, that those in government occupying senior leadership roles in government had a fear that if the NPA went after the former generals on the security branch side, the apartheid-era security apparatus, that would then give rise to call or pressure for prosecutions against the ANC as well. And does that explain why there were these attempts to put obstacles in your way in relation to the Jucani prosecution and the others as well?
Commissioners, I must say that it was not an unfounded fear. Because what also had to be taken into account is that when the 37 ANC leaders or members applied for amnesty, that application was turned down. Therefore, in terms of the law, they were open to prosecution, depending on the nature of investigations and whether there was sufficient evidence that would justify a prosecution. Thank you, Commissioners.
But by then, I believe it was your predecessor had made it clear that there was insufficient evidence, and I believe there was a press release to this effect.
Yes, Commissioner, thank you very much. And it's in the bundle as well, the question of a press release which was issued, around this matter.
So what then was the context for this lingering fear?
I don't want to speculate. Thank you, Commissioner.
Well, we will be returning to that when we deal with the attempts to discredit Advocate Ackerman with the forged letter, which I think will help to explain. But we'll come to that later in the day. Mr. Bikoli, part of the terms of reference of this commission is to explore what was behind the stopping of the TRC cases. And largely based on what was said at this meeting, but also in relation to other developments, the families will be submitting to the Commission that the fear of the NPA coming after ANC members and ANC leadership, since that pressure would be applied if the NPA went after the other side, namely the apartheid-era police officers and generals, that really explains all the effort made by members of the executive to control and curtail prosecutions of the TRC cases. Would you agree with that assertion?
Can you come again? Please?
Sorry?
Can you come again?
Yes, sure. So part of the terms of reference requires this commission to explore what was behind the stopping of the TRC cases. And we will be submitting that the bulk of them were stopped. We intend to submit that on the back of this kind of evidence, in a meeting of cabinet ministers, one of them says, if you go after the one side, the apartheid-era police officers, then there will be pressure for you to come after the ANC side as well. And our submission will be that that explains their concerns and it explains the steps that they took.
Thank you, Commissioners. Let me respond to that question by putting known facts on the table. And the known facts are that SAPS and other departments were not willing to assist the PCLU to do its work as mandated. That's one. Two, when, even after I had pronounced on the Jucani matter that the NPA has taken a decision to prosecute, a decision taken in February 2006, but actually a decision that was taken way back in 2004 to go ahead with the Jucani matter. And now we're sitting in 2006 where there's still no prosecution in the Jucani matter, which tells you that, rightly or wrongly, for whatever reasons, this matter was kept in abeyance. The prosecution was suspended in 2004. And to jump a little bit and say, when we then went ahead with the Jucani matter, which finally went to court on the 17th of August, 2007. Very soon thereafter, just over a month, I got suspended because I had proceeded, or the NPA had proceeded with this matter. Within a month, 17 August 2007, 23rd September 2007, I get suspended. What was the message that was being sent through to anybody who was going to occupy the position of the head of the NPA? And again, to show that this is not far-fetched, again, a matter which I know that you have not really started talking about. One of the charges that I faced at the General Commission included the question of the prosecution in the Jucani matter, which was in the government case, in the submission by government. But then when I started responding in 2008 on that accusation, government withdrew the charge. A lot can be read into that. I said it deliberately when I said that I believe that the Jucani matter was a test case in terms of the political will, whether to go ahead with the prosecutions. That would be my case.
Thank you, Mr. Piccoli. Chairperson, I see it's almost 11. Would this be an appropriate time for the agenda?
Yes. We'll take a tea adjournment until 11:15.
As the Commission pleases.
Mr. Vani?
Thank you, Chairperson. Mr. Pikuli, I'd like us to return to your affidavit that you made before the Jinwala Commission. And if I can draw your attention to page 143 of your bundle. It's bundle 2.
123. 43.
Yes, Chair.
It's page 143.
Okay.
And can I ask you to read into the record from paragraphs 276 to 279?
Thank you, Commissioners. Paragraph 276. It was following this meeting that a meeting took place at the Office of the Presidency, which is dealt with in paragraph 4.2 of my memo TRC 1. My understanding and recollection of the meeting was that the role of the working group was that set out in paragraph 4.3 of TRC 1, that is, the working committee or task team would not make recommendations on a decision as to whether to prosecute or not, but would be responsible for ensuring that the NPA obtained the necessary information or such inputs as were appropriate from the various departments so as to assist and enable me to reach a well-considered decision whether to institute proceedings or not. The task team would deal with all relevant matters identified by the PCLU and SAPS. Paragraph 277. I have no recollection whatsoever of any suggestion at this meeting of the establishment of a separate committee of DGs which would receive reports from the task team. Had there been any suggestion that the task team members would report back to the DGs, who would in turn make recommendations to me in regard to the question of whether to prosecute or not, I would have objected to this, as it would have amounted to falling back to the position originally suggested before the guidelines were established and which had been rejected by all parties as unconstitutional. Paragraph 278. At this meeting, I proposed that Dr. Ramayite should chair the task team. I suggested this in order to deal with the complaints in regard to Advocate Ackerman's position and as a concession to get the task team working. The proposal was accepted by those at the meeting. Dr. Ramayite is the Deputy National Director of Prosecutions, to whom the PCLU reports. Paragraph 279. Subsequent to this meeting, there was a further meeting of ministers in the security cluster at the office of the Minister of Safety and Security. This was attended by the Minister for Safety and Security, the Minister of Social Development, Acting Minister Titiza, Mr. Silibe, various DGs, and Mr. Jafta. The proposal for the establishment of a working group was put to the ministers. It was agreed that the proposed working committee would proceed. Once again, I have no recollection of any suggestion of a separate committee of directors general or that the task team would be reporting to such a committee. Paragraph 280.
Actually, you can pause there. We'll come back to 280 in a minute or two. The reference to this separate committee of DGs, was that not a reference to the already existing DGs forum?
No, you recall that with the guidelines now and the amended prosecution policy, it was a question of a task team that would be assisting the investigations by the PCLU. Nothing about the DGs forum anymore in terms of the guidelines and the,
So
and the amended prosecution policy.
In your view, the DG's forum effectively fell away.
There was no such after the adoption of the guidelines.
Right. And in paragraphs 276 and 277, you make reference to the fact that the original proposal that the task team members would report back to the DGs, who would in turn make a recommendation to you as to whether to prosecute or not, that that had been rejected because it would have been unconstitutional.
Yes, Commissioners. Yes, Commissioners. That was rejected. Hence, it did not find its way into the guidelines and the amended prosecution policy. That's evidence of such a rejection.
So as far as you were concerned, you didn't have to wait for a recommendation from anybody before you made a prosecutorial decision.
That is correct, Commissioners. And this is borne by letters which I can send out, wherein the National Commission of Police was stating a different position on the question of the role of the DGs, and it's in the bundle.
Right. And of course, this was going to become the big bone of contention, which we will come to shortly. Perhaps you can continue from paragraph 280 to 283, please.
Thank you, Commissioners. Paragraph 280. After this meeting, letters were again written to the various Directors General, Mr. Silibi and the TSO, in early October 2006, inviting them to nominate a senior official to perform the functions set out in paragraph B6 of the guidelines. In brackets, an example of such letter appears as Annexure A to the affidavit of Assistant Commissioner Jacobs. The letters were in the same format as those sent out in January 2006, at the time of my first attempt to secure assistance. The letters were drafted for me and referred to the appointment of Dr. Ramaite to head and supervise the prosecution processes of all TRC-related matters.
Actually, can we just pause there and refer to that letter? So in your bundle, if you can turn to page 114. So there, are you at page 114?
Yes, I am.
So there's a letter there from the Office of the National Director of Public Prosecutions, and it's addressed to Commissioner Selebi, and it's dated, looks like it's the 9th of October 2006.
That is correct.
I think I'm correct in saying that is the letter you are referring to. Perhaps you can read that letter into the record.
It's addressed to Commissioner J. Silibe, National Commissioner of Police, SA Police Services Headquarters, Pretoria, 0001. Dear Commissioner Silibe, and the heading, Prosecutions of Crimes Emanating from Conflicts of the Past. As you are aware, the prosecuting policy with regard to criminal matters arising from conflicts of the past came into effect on 1st December 2006. I think it should have been 5. In terms of the said guidelines, all such prosecutions will be conducted by the Priority Crimes Litigation Unit, PCLU, which is located in my office. I have appointed Dr. Silas Ramaite to head and supervise the prosecution process of all TRC-related matters. In terms of paragraph B6 of the guidelines, the PCLU shall be assisted in the execution of its duties by a senior designated official of your department. You are therefore kindly requested to nominate a senior official or officials to perform the above function. You are further requested to make such official available to attend a meeting to be held in the boardroom of the National Director of Public Prosecutions, VGM Building, 123 Westlake Avenue, Weaven Park, on Thursday, 12 October 2006 at 14 hours. You are also kindly requested to attend this first meeting. Your assistance and cooperation in this regard will be highly appreciated. Yours sincerely. Then my signature.
Thank you, Mr.
Dated
Yep.
9 October 2006.
Thank you, and we're going to return to that first meeting shortly. But can you continue reading to the record from paragraphs 281 to 283? So that's at page 145.
Thank you, Commissioners. Paragraph 281. The task team met for the first time on 12 October 2006. The minutes of the meetings of what became referred to as the task team on TRC cases are annexed to the affidavit of Commissioner Jacobs, save for the minutes of its meeting on 8 October 2007, a copy of which is annexure TRC 3 hereto. As is commented on by various parties, the minutes of these meetings are not a full record of all of the issues canvassed. As the meetings reflect, I attended the opening session of the first meeting together with Ms. Plea, the Directors General of the NIA and Justice, and Mr. Jafta from the Presidency. The details of my address to the task team are set out in paragraph 4.3 of TRC 1. I recollect dealing expressly with a question by a representative of the NIA who raised the issue of whether it was the function of the team to make recommendations on a decision whether to prosecute or not. I indicated clearly that the decision as to whether to launch a prosecution rested with me and not with the committee. Paragraph 282. I have noted the terms of the final sentence of paragraph 1 of the minutes of this meeting, stipulating that the role of the committee will be to make recommendations to the NTPP on each case. It was indeed the responsibility of the task team to assist in the process of obtaining the requisite information or assistance from the various departments so as to enable me to reach a decision as to whether to prosecute or not. There was, however, definitely not any suggestion that a recommendation by the task team on whether to prosecute was a prerequisite for any decision that I might take. To the extent that the terminology referring to the making of recommendations by the task team in this and other TRC-related documentation is interpreted to support that contention, this is both regrettable and wrong. Paragraph 283. I did not participate further in the activities of the task team, which was conducted under the chairmanship of Dr. Ramaite. I received reports from time to time on their activities. It was certainly my understanding that the committee was functioning and securing the requisite cooperation from the other agencies which had previously been missing. I refer in this regard to the affidavit of Dr. Ramaite. Paragraph 284.
Actually, we can pause there for the moment. We'll come back to those paragraphs. Am I correct in saying that the assumption you made at that time, that the committee was functioning and securing the requisite cooperation from the other agencies, that in due course you would discover that actually that cooperation was not forthcoming?
That is correct, Commissioners.
So let's then turn to the meeting in question, that first meeting. If I can ask you to turn to page 115 of your bundle, the same bundle that you're currently in. And that document is titled TRC Committee Members, the members of that particular task team. And just to point out that at that first meeting there were 3 NPA members present, a member from Justice, 2 members of NIA, 2 members of SAPS, and 2 members from NPA DSO. And then under principals, you are listed as NDPP, as well as Kalyani Pillay from the NPA, Loyisa Jafta Presidency, and I'm assuming that's Menzi Simelane, DG of Justice, and Mr. Manzini from the National Intelligence Agency. Can you explain the difference between the principals and the members?
Well, the TRC committee members, commissioners, were the ones who were going to ensure that there is cooperation and collaboration in terms of ensuring that investigators would be availed to the PCLU, and then also to place any other information that might have been required for purposes of making a considered decision on the question of for prosecutions, just to place that information which might be relevant, and then also to make sure that there is cooperation, that the various departments will make investigators available. And then, well, here you then have, for instance, when it says the NPA, I'm referred to there. Kalyana was an advisor in my office. May her soul rest in peace. And then, of course, what I really cannot really explain is the presence then of Mr. Loyisa Jafta from the Presidency again. And then, obviously, Mr. Menzi Simelane as the DG of Justice, and then Mr. Manala Manzini, who was the DG of the National Intelligence Agency at the time. Just for purposes of ensuring that there is the desired cooperation, as I've mentioned, what I meant by this. Thank you, Commissioners.
So when you say that you can't really explain the presence of Loyisa Jafta from the Presidency, why can't you really explain his presence there?
It's because by this time we already had the guidelines in place and the amended policy in place. And then also the task team, the members were outlined in the guidelines. Yesterday, I did indicate that the presence of somebody from the Presidency, it did not really bother me. I was prepared to have, to have a representative from the Presidency. I know we had a discussion on that yesterday. Look, what was operating in my mind really was to choose the battles that I wanted to fight. I didn't want to engage in endless battles which, will not enable the NPA to do its actual functions, as later evidenced by the fact that immediately we went ahead with just one case, the Jucani matter. The volume was, or the heat was sort of switched on in terms of the work of the NPA. So I was clear that I'm going to choose my battles. But I had my bottom line.
Yes. But am I correct in saying that if one looks at Part B of the amendments, the guidelines, and the list of organizations that were meant to support the NPA, the Presidency was not listed as one of those organizations?
Yes, that is correct, Commissioners.
So in fact, properly speaking, the Presidency shouldn't have been represented here.
Stricto sensu, yes.
But it does reflect a desire by the Presidency to be involved at this level.
Yes, I would say so. Undesirable as it might have been, but yes.
Yes. So we can also presume that the Presidency and possibly President Mbeki himself would have been kept informed of developments.
Well, it would make sense if the Presidency is represented, that whoever is from the office of the President would be reporting to the President.
All right, let's turn to the first meeting of the TRC committee or the task team, and that's actually on page 116. And it was attended by 15 individuals, and it looks like these are the same individuals mentioned in the list on page 115. I want to draw your attention, and I see the apologies was received from the National Commissioner that was written in. I want to draw your attention to paragraph 3. It says, Dr. Ramaita indicated that there is a need for a task team of investigators to work on these cases. So that reflects that, towards the end of 2006, the NPA was still looking for investigators.
That is correct, Commissioners.
And if we turn the page over under the heading committee meeting, Dr. Ramita requests the PCLU and SAPS to compile an audit report of all cases in their possession, and that the PCLU will take charge of investigations being assisted by SAPS. The committee will then deal with all cases, including matters that have been closed by the PCLU. And the next sentence is the one I want to highlight. Mr. Ngidi indicated that committee members will not be rubber stamper, I think that should be, will not be rubber stamps to decisions already made by the PCLU. And he was supported by Mr. Kupedi, who said they are prepared to go through volumes of records in all cases. So what did you take to mean by Mr. Ngidi? And Mr. Ngidi was from the DSO, and Mr. Kupedi
From the NP, from NIA.
From NIA, exactly. So what did you make of them saying that there will not be rubber stamps to decisions that the PCLU and the NPA are making?
Thank you, Commissioners. Sorry. I'll deal with the first part. What Mr. Nhlanhla Ngidi, that's his first name, said for me, it was a further indication that things were not really settled within the NPA between the TSO and the PCLU. And we do have the history of this animosity. So Mr. Ngidi, coming from the TSO, was sort of perpetuating those tensions that they are not going to serve as a rubber stamp, which is fine, because their job was to, properly consider everything that would have been placed in front of them. Mr. Kopedi, from the NIA, obviously was showing willingness to say that they're prepared to go through volumes of records in all cases. I suppose then this would have been in the possession of NIA, because also being a member of NIA might have known what was not known by other members of the task team, which then, puts this thing in proper perspective, that all information that might not have been in the possession of the NPA will be availed so as to enable the NPA to take an appropriate decision. That would be my take. Thank you, Commissioners.
Thank you. So let's then turn to page 118 of your bundle. And this is an information note. It's undated and unsigned, and it's from the Assistant Commissioner P.C. Jacobs, who was then Head of Legal Support Crime Operations at SAPS, and it's addressed to Divisional Commissioner Detective Service J.F. De Beer. But in the first paragraph, he refers to the last meeting of the subcommittee. We don't know which meeting he is referring to, but since Dr. Ramaita had requested investigators, it might have been after that committee meeting. And you can see from paragraph 2 that there's a recommendation regarding possible prosecution of various cases. In paragraph 3, he refers to a discussion held with Advocate Ntunzi Maga of the PCLU in order to obtain guidance on where investigators are needed. And then they list various cases. I'm not going to go through all of them. There are 8 cases listed. And he finishes off in paragraph 5. It is recommended that detectives in the respective areas be identified and their contact particulars be given to Advocate Maga in order to make the necessary arrangements for the investigations to proceed. Were you aware of that initiative at that time?
No, Commissioners, I was not aware, but of course, that's what would have been expected.
Yes. And now if one looks at the cases, one would have hoped that at least these 8 cases would have gone ahead in one form or another. So 4.1, well, there we know that the PEPCO 3 case was already underway. That had been previously investigated according to Advocate Ackerman. Now the cases that our families are familiar with, apart from PEPCO 3, would be the Craddock 4 case and the COSAS 4 matter. Now, dealing with the Craddock 4 matter, the families, and in particular the families associated with the Craddock 4 case, they contend that no serious investigations took place in the Craddock 4 matter until the docket was reconstructed in 2019. And I'd like to refer you to Bundle 1 at page 129, paragraphs 3 to
page
129.
Yes, I'm there.
And under the heading, the missing Craddock 4 docket, so that runs from paragraph 328 to paragraph 332.2. And essentially what Lucanio Kalata is saying here, and he's the son of the late Fort Kalata, one of the Craddock 4, that in fact the docket had gone missing during 2013 and had to be reconstructed in 2019. And I'll also refer you to paragraph 332, where he refers to an affidavit made by Advocate McAdam in the application to compel a decision in that case that was brought by the Craddock 4 families in 2021. And an Advocate McAdam's affidavit, and I believe it is part of our record, and I'll ask my team to find it, is that the missing docket only comprised of an inquiry into unfounded rumors against one General Hankel and the old inquest and TRC records. So that then prompted Mr. Kalata to conclude that prior to 2013, and I'm at paragraph 332.1, little or no substantive work was conducted in the decades between the Zietsman inquest and the TRC in the early to mid-90s, and the reconstruction of the docket that commenced in 2019. And that meant that there was a suspension of substantive work on the case for more than 20 years. So, Mr. Pikuli, even though it seems that there was a request in this undated, unsigned information note for the Craddock 4 case to be pursued, which would have been very welcome given that there were many suspects alive at that stage, do you agree with the families that, in fact, it wasn't pursued in any serious manner?
Yes, I do agree, Commissioners.
And then let's turn to the other matter that we are familiar with, and that's the COSAS 4 matter. It's at 4.5. It says COSAS 4 Krugersdorp. And there I want to refer you to Bundle 1 again, at page 167. And I'm referring to paragraphs 430 to 436. And you'll see from paragraph 430 that in September 2019, the families of the COSAS 4 requested the NPA and DPCI to investigate the murders of the 4 teenagers in 1982. And ultimately, the families, out of frustration, decided to take matters into their own hand. On 2nd September 2020, they filed an application with the Krugersdorp Magistrates Court seeking an order for the disinterment and forensic examination of the bodies. And at paragraph 431, in her founding affidavit in that application, Maida Christina Salebi, the sister of Eustace Bimba Madikela, one of the COSAS 4, noted that her legal representatives had meetings with the NPA and DPCI, as well as written multiple communications, several of which were ignored. She noted that several high-ranking suspects had already died, and that it had fallen to the families to bring this application. She recalled that the COSAS formatter was handed over by the TRC to the NPA in 1999, and that the families bring this application to find peace and closure. And that extract from her affidavit is quoted. We have been forced to take matters into our own hands. We can no longer be expected to wait for the NPA and SAPS, who have already delayed this matter for some 21 years, to act. I'm pleased to advise that after that intervention, the NPA did, in fact, act. And in August of 2021, 2 individuals were charged with the kidnapping and murder of the four teenagers. But you will agree, do you agree with me that the COSAS formatter, which could have been pursued, for example, from 2006, when there were more suspects alive, in fact, it wasn't pursued, and the families had to take action in 2020?
Commissioners, yes. But again, I still want to confine issues to the time I was in office. And what I've said already is that my first attempt is the NTPP after my appointment in 2005. Stopped when we pursued the Jucani matter, which actually went to court. Some I do state that though the matter was settled in terms of Section 105, capital A, I would have preferred a full trial. But given all the resistance that we were going through, I still felt that, look, if we go ahead, we'll be able to achieve a conviction, at least to be on the record, that there are senior ranking officials, including a minister of the previous apartheid regime, who were actually convicted, of apartheid atrocities. This would have been Flock, who was the Minister of Police, and Von der Merwe, who was the National Commissioner, and then Otto Smith, who later became also a general, and then the others were colonels, I think, who received the conviction. Personally, I would not have preferred that situation. But it's something that we had to live with, given all the resistance. I don't want to go back to that. So, and then this happened in August 2007. I get suspended in September 2007. Clearly, there's a huge gap between what is referred to here, between the time of my suspension and leaving, finally, after a settlement with government, when I left the NPA. So I left in 2007. Now there was a huge gap. History will show that there was this gap up until there was a new administration in 2018. And then, of course, that was to fill a gap that was left when President Zuma left the presidency, which was in 2018. Now, this would explain that there was sort of a change in attitude from that time, where there was, some willingness on the part of the NPA, but I was not there at the time, so I can't speak to that. But judging from what is contained in these bundles, it's something that has got to be taken into account. Thank you, Commissioners.
Thank you, Mr. Bakuli. Let's then turn to page 123 of your bundle, the same bundle that we're in. And you'll note that this is an internal memorandum that was prepared by Advocate Ackerman and his team. It was addressed to Dr. Ramaite and copied to yourself and Advocate Plea. The two subject lines: details of TRC cases closed by the PCLU, and secondly, reappointment of Senior Superintendent Brits, and it's dated 30 October 2006. And he points out in his first paragraph that on 25 October 2006, the PCLU was requested to furnish these details. And at that first meeting, you'll recall that that request was made. So it's a long memo. We're not going to go through it in any great detail. Paragraph 2 deals with TRC cases closed. And there are a number of cases, some high profile, like Ahmed Timol, Steve Biko, various others. So we can skip those. But it looks like many cases were closed. Certainly more than 25. Actually, it looks like it's 27. Let's pause at paragraph 2.28, which is at paginated page 132. And this deals with the reappointment of Senior Superintendent Brits. And I want to pose a question to you on the first 5 paragraphs. It says, at the last meeting, the committee was informed by Assistant Commissioner Jacobs that Senior Superintendent Brits would be reappointed to investigate the dockets in possession of SAPS. And Ackerman says, I wish to express my concern at this. Brits was a former member of the security branch who, prior to the PCLU being involved with TRC cases, assisted the DPP Pretoria with cases involving the liberation movement. Former Police Commissioner General van der Merwe had formed an organization entitled the Foundation for Equality Before the Law, which was intended to ensure that no further prosecutions of security branch members would take place. When I and my staff were appointed to take over the TRC cases in the DPP office, Pretoria, we gained the firm impression that Brits was not only very sympathetic towards this organization, but had regular contact with General van der Merwe, in particular Brits, and here we're talking about a detective by the name of Henny Brits, tried to persuade me and my deputy on numerous occasions that there was a provable case of terrorism against President Mbeki arising from the landmine campaign. This was raised in the context that there were security branch members to be prosecuted. The president would also have to be charged. It was clear that he was against prosecutions of security branch members. Despite his claims, he could never produce a docket implicating the president. At one stage, he informed me that the docket was with General van der Merwe and his legal advisor. This raises a very serious question as to how an official police docket could be retained by General van der Merwe, who was not entitled to possess police material after his retirement from SAPS. So, what does this say about the approach of SAPS to these cases, that they wish to appoint a senior detective who seemed to be working in cahoots with the former security branch and was even passing on information, according to Anton Ackerman, to former Police Commissioner General van der Merwe?
Thank you, Commissioners. First, let me align myself with the reaction of my predecessor on this particular matter, because what he did on hearing of this is expressed in no uncertain terms, to the extent that, he didn't want anything to do with the spreads and whatever that they were doing there. I expressed a similar disgust. And then how one would have expected, a proper investigation when people that already obviously had taken positions. And also, as far as my position is concerned as well, and as a former combatant of Umkhonto weSizwe, I didn't have problems in terms of the ANC or members of Umkhonto weSizwe being able to explain themselves in terms of what happened during the armed struggle. I'm saying this because there's a reference here to the question of the landmines. I'm saying this with the comfort of knowing that the ANC had signed the Geneva Conventions, particularly the additional protocols of 1977, justifying the ANC and through its military wing, Umkhonto weSizwe, being engaged in the armed struggle. It was a just fight, it was a just cause. Therefore, it would not be a problem for any member of the ANC who would have been accused of anything that fell within the ambit of conducting a just war. Now, we have got the people against whom the ANC, the PAC, the PCM were fighting against, who were defending an unjust cause, who had gone to the extent, even post-1994, to have formed an organization. And you still have those people, of course, sunset clause, they were still there because they didn't want to destabilize, the work of government. And you have a person like Brett, who's mentioned here, associating himself and his thinking, perhaps understandably so, because the security branch, they were the ones who were at the forefront of persecuting political activists. Now to have such a person, so this is what I'm saying, I fully align myself with what on this matter, and therefore also, looking at this, I would have been equally disgusted to have such a person. Thank you, Commissioners.
Yes. He was in fact removed, as you will see from the rest of that memo. But let's move on. Can I ask you to return to your Jinwala affidavit, the affidavit you made before that commission, and I kind of draw your attention to page 147 of the same bundle that you're in.
So, what page is that again?
147.
Thank you.
And can I ask you to read into the record two paragraphs? That's paragraphs 284 and 285.
Thank you, Commissioners. Paragraph 284. In December 2006, Dr. Ramaite reported to me in regard to the contention raised by Mr. Silibe through Commissioner Jacobs that it was the function of the task team that it should make a final recommendation to a body identified as the Committee of Directors General, which would in turn make recommendations to me. The developments in this regard are dealt with in paragraphs 4.4.1 to 4.6 of TRC 1. In essence, the proposal made by Mr. Silibe and subsequently supported by the Directors General of Justice and NIA amounted to a reversion to a two-stage process in which my decision on any prosecution would be dependent upon a prior recommendation by an intervening committee of Directors General, which would be subject to the same constitutional challenge as had led to the rejection of this proposal in 2004. Paragraph 285. It became clear to me that there was a material misunderstanding in regard to the role of the task team, and that unless this was resolved, I would not be able to carry out my functions within the contemplation of the relevant legislation and as envisaged by the government. Paragraph 2.
Sorry, Mr. Pikoli, can we just pause there? We'll come back to the rest of those extracts shortly. But can I just refer you to some of the relevant documentation in relation to these developments, starting with a letter that Commissioner Salebi addressed to yourself. And if you can turn to page 172 in the same bundle.
I'm there.
So perhaps, can you see the letter at 172? Is it before
Yes,
you?
I'm there.
Okay. So this is a letter addressed by National Commissioner Salebi to yourself, Advocate Pikoli. And it is dated looks like it's the 6th of February 2007.
That is correct.
Can I ask you to read into the record from the heading Outstanding TRC Cases to the end, please?
This is how it reads. I have been briefed. This is from the National Commission of Police to the National Director of Police Prosecutions. He says, I have been briefed on the last meeting of the task team set up in terms of the Cabinet guidelines on outstanding Truth and Reconciliation Commission, in brackets TRC matters. It was brought to my attention that in State versus Otto, complainant being Reverend F. Jucani, a decision on prosecution was taken without consultation with the respective departments. I have insisted that the complainant be consulted in terms of the guidelines on the basis that the Directors General will have an opportunity to provide input before a decision on prosecution is taken. I am also under the impression that there is no common understanding on the process to be followed. My understanding was that the officials designated on the task team by the Directors General will provide recommendations to the Directors General, who will, as a collective, advise the National Prosecuting Authority as the decision maker on prosecutions. In my view, a comprehensive report such as the one directed to the NPA, dated 24th November 2006, and revised on 29 November 2006, should be discussed by the Directors General. Although I do not insist on a meeting of the Directors General after each meeting of our officials, I deem it necessary that the substantive reports and recommendations of the officials should be discussed by the Directors General before a decision is made. I am of the opinion that the Directors General should meet as soon as possible to provide guidance on the procedures to be followed by the officials in the task team. I am also of the opinion that the Jucani matter should be discussed both in terms of the procedures followed and the way forward. I have requested the NPA to convene a meeting as soon as possible and trust that you'll be in agreement with that request, with kind regards, signed by the National Commissioner. Dated 6th, I think it's February.
February, yes.
6/2/07, which would be 2007.
So in that fourth last paragraph, Mr. Pekoli, Mr. Salebi seems to be making it clear that before you can make a decision, the DGs will need to first discuss the substantive reports and recommendations of the officials of the task team. Is that a correct interpretation?
That is correct, Commissioners.
I noticed that in the first paragraph, Commissioner Salebi, the late Commissioner Salebi says, I've been briefed on the last meeting of the task team set up in terms of the cabinet guidelines on outstanding TRC matters. When he refers to cabinet guidelines, what was he referring to?
I suppose because there were no cabinet guidelines other than the guidelines and the amended prosecution policy following the tabling of the amended prosecution policy. And so far as cabinet guidelines, I don't know what it was.
Perhaps it was something of a misnomer, but since he probably was aware that the guidelines had been approved by Cabinet, he simply called them Cabinet guidelines. Of course, that is...
That's fair enough.
I accept that is speculation.
Yes.
Now, this very same letter, am I right in saying that it was also sent to the other members, or rather the principals of the TRC committee or that task team? So, for example, if you turn to page 173.1, there's an exact copy of that letter addressed to Menzi Simelane, DG of Department of Justice.
That is correct, Commissioner.
And similar letters were also sent to the other principals in NIA and so on, although we don't have those annexed here. Can we then turn to your response?
Yes, Commissioners.
Which was actually sent on the same day. That's at page 174.1. It's addressed, it looks like it's the date of the 7th of February.
No, 6th.
Oh, sorry, it looks like I'm on the wrong page here.
It's 174.
Yes, it's 174. Sorry, I was confused because in my bundle there's also 17.1, which is before 174. So if we can go to 174, this is a letter from your office to Mr. J.S. Salebi, dated 6 February 2007. Please could you read this into the record from Dear Commissioner Salebi?
It said that outstanding TRC cases, which was a response to the letter which you had received on the same day. It says, your letter of 6 February 2007 refers, I advise that it is clear that our understanding of the mandate of the task team, as well as the guidelines that Cabinet approved, are not the same. In the circumstances, this matter, as well as other issues that have emerged in the course of the NPA dealing with the TRC cases, are currently being taken up with the Minister of Justice and Constitutional Development.
Thank you. And then if we can go back one page to 174.1, on the following day, the 7th of February 2007.
Sorry, 17?
I'm not sure whether your bundle is the same as mine, but it's the preceding page. Or maybe it's a subsequent page.
The letter that I responded.
No, it's page 174.1.
No.
You don't have a copy of that.
174 is only the letter where I was responding
On the
to National
following
Commissioner.
page, Advocate Piccoli,
Pardon?
on the following page after 174.
No, the next page is 175.
We're just going to
don't have
give you that.
174.1.
Yes. Now I've got 174.1.
Yes, sorry about that. This is a letter from Advocate Menzi Simelane, Director General, Department of Justice, dated 7th of February 2007, and it is addressed to National Commissioner Selebi. Can you read into the record from dear colleague?
Thank you, Commissioners. The letter is from Advocate Menzi Simelane to the National Commissioner. Subject outstanding cases. Says your letter in the above matter dated 6 February 2007 refers. I am in agreement with the sentiments contained in your letter. Indeed, I was also expecting that the Directors General would be consulted formally in a meeting on the decisions regarding TRC cases. Whilst I agree that an urgent meeting of the DGs be convened, I am of the respectful view that it must also be to obtain a detailed report on all the cases on which the task team has deliberated and to recommend how those cases should be finalized. I would like to propose that, as most of the Directors General will be in Cape Town, the meeting should take place there tomorrow or Friday, 9 February 2007, with kind regards, signed by Advocate Menzi Simelane.
Thank you, Mr. Piccoli. Thanks, Mr. Piccoli. So, would I be right in saying that at this moment was something of a tipping point for you?
Yes, Commissioners. Clearly, there's one view or interpretation by the DGs, the National Commissioner, and our understanding in the NPA of what was meant, in the guidelines, particularly as it refers to the question of the NPA and its independence.
So I want to put a paragraph to you from the affidavit of Lucanio Kalata, and I must ask you to go back to bundle 1, please. Page 100 of bundle 1.
Page 100.
Yeah.
Yes, I'm there.
So I want to put this paragraph to you and seek your reaction. And it's paragraph 236.
Page?
Page 100, Madam Chair. And at the bottom of the page, paragraph 236. The penny finally dropped with Piccoli towards the end of 2006. Up until this point, he had operated on a good faith basis that his counterparts in the other departments in the ITT would support him to resolve the TRC cases. In fact, they never had any such intention. It is quite apparent that they saw their role as clamping down on the cases from proceeding. Since it appeared to them that Piccoli might act on an independent basis, the communication from Major General Philip Jacobs made it abundantly clear that Piccoli was not to act without their permission. Would you agree with that contention?
Thank you, Commissioners. Perhaps the Commissioners might have seen a smile on my face because I was just marveling at the opening sentence, the penny finally dropped with Pikoli towards the end of 2006. Again, I just want to make it clear that, I had never at any stage tried to, not to be part of this process. At the time, I was the Director General of the department. And I was genuine in my belief that, it's never going to end up interfering with the independence of the NPA. So I do agree with the sentiments as expressed in this paragraph. Thank you, Commissioners.
Yes, and to make it clear, Mr. Pikoli, that there's no suggestion from the family that you were disingenuous. Indeed, Mr. Kalata makes it clear that you operated in good faith and that you expected cooperation from your colleagues. So we just wish to place that on record.
That is correct, Commissioners.
In that case, let's move on, and I'm going to draw your attention, and sorry to do this, but can we go back to your own bundle? That's bundle 2. And I want to draw your attention to a letter that the then Minister of Justice, Bridget Mablanda, addressed to you, dated 8th February of 2007, and it's in your bundle at page 39.
Yes, I'm there, Commissioners.
So this is a letter from Mrs. B.S. Mabandla, then Minister of Justice. It's addressed to yourself. It's dated 8th February of 2007. Can you read this into the record from Dear Advocate Pikoli?
Yes, it's addressed to the National Director for the Prosecutions from Minister Mabandla. It says, Dear Advocate Pikoli, subject TRC matters. Our discussion in the above matter on Tuesday, 6th February 2007 refers. I must advise you at the outset that the media articles alleging that the National Prosecuting Authority will go ahead with prosecutions have caught me by surprise. In our discussions, you briefly mentioned to me that the NPA will not be going ahead with the prosecutions, as you had undertaken to advise me in writing. I will appreciate it if you could advise me urgently on the matter so that there can be certainty. I trust that you find the above in order. With warm regards, signed by Mrs. Mabandla, Minister.
And before we discuss that letter, if you turn to the next page, that's page 40, it appears that this is the article that the Minister was referring to. It's quite a long article, so we're not going to read the whole article into the record, but it's from News 24. It's titled, Cops Up for Apartheid Crimes. It's dated 7th of February 2007. Looks like it was released at 07:15 in the morning by two journalists, Jan Joubert and Willem Jordan. And it says the NPA has informed 3 security policemen that they are to be prosecuted for apartheid crimes. So the article essentially deals with the decision of the NPA to proceed with the Jucani matter. Am I right in saying that that is the article that the Minister was referring to?
That is correct, Commissioners.
And the Minister also referred to a discussion between the two of you on Tuesday, 6 February 2007. Do you recall meeting with her on that day?
That is correct, Commissioners.
And can you indicate, why that meeting was held and what was discussed?
The coincidence here is that I received a letter on the 6th of February from the National Commission of Police on this matter. And then again, I have a discussion with the Minister of Justice on the same matter. That's why, for instance, in my response to the letter of the Minister, which had to give a detailed explanation, there's no way in which an expectation from her side could have arisen on the question of not going ahead with the prosecutions. The Commission will be able to recall what I've been saying or testifying orally, and also what is in the bundles, that the first decision was taken by the NPA not in 2007, not in 2006, though I made it clear in 2006 that the NPA will go ahead. The decision was taken in 2004, even before I assumed my responsibilities as the National Director. There's nothing which could have come as a surprise to the Minister of Justice. It was the intention has always been there. Actually, if one were to go according to the submission or affidavit submitted by Dr. Ramaite, she is the one who gave an instruction to the acting National Director of Public Prosecutions to put this matter in abeyance. And since then, nothing could have come as a surprise or a shock, because when I was in office, there's always been an intention to go ahead with these matters. Yes, I participated in the process of the amendment of the prosecution policy because I'm enjoined by the Constitution, because it's there in the Constitution that the prosecution policy is determined by the National Director, but with the concurrence of the Minister. So the Minister was always involved in this process. She knew. That's why in my response to her, I say, I don't know what could have given rise to such an expectation. Thank you, Commissioners.
And on that score, can I refer to your 2015 affidavit in the same bundle at page 19? And can I ask you to read paragraphs 49 and 50 into the record?
Perhaps even before I do that, responding to your previous issue that you raised, and perhaps the expectation on the part of the former minister, perhaps she could have mistaken as she had given me that instruction, which she gave to the acting National Director of Public Prosecutions. Now coming back to...
Yes, could you read into the record paragraphs 49 and 50 from your 2015 affidavit?
Paragraph 49 on page 19. I am at a loss to explain how the minister reached such a conclusion. Her letter disclosed an assumption that the TRC matters will not be prosecuted. I found this to be a disturbing development, as it appeared that at a political level, there was an expectation that I would not prosecute the TRC cases. I regarded such an expectation as unwarranted interference in my constitutional duty to prosecute without fear, favor, or prejudice. Paragraph 50. It is most likely that I would have clarified my position with the minister, either through a meeting or a telephone discussion. I would have confirmed to the minister that it was not my intention to drop the TRC cases.
Thank you. Now, Mr. Bakoli, in our consultations, you mentioned that sometime between the 8th and the 15th of February, you had a meeting with the minister, and during that meeting, the question of your oath of office came up. Could you just elaborate on what happened in that meeting?
For which year?
Yes.
The same year, Commissioner, so that would be between the 8th and 15th of February 2007.
Okay.
Thank you, Commissioners. Firstly, let me say that when I was admitted in 1995 as an advocate in Cape Town, obviously I had to take an oath, which I did. And then the second one was when I became the National Director of Public Prosecutions. That was the second oath. The first one, if I'm not mistaken, was administered by Judge Friedland. I think it was the Judge President of the Western Cape in 1995, if I'm not mistaken. The second one, it was by Judge Ngwepe in Pretoria. And you would have noted that every time, I make an issue in terms of the independence of the prosecution, I would talk about the oath of office that I took. So also, in my discussions with the ministers on these matters, I will always refer to the oath of office, to such a point that I think she became annoyed with my reference to the oath of office. She went to the extent of saying, Vusi, you're not the only one who has taken an oath of office. I've also taken an oath of office. I must say that, I was shocked, I was surprised that she could have an issue with me referring to the oath of office. Because my point was that I take an oath of office very seriously. Perhaps this has got something to do with my own upbringing, starting as a scout boy.
Where you take the Scout's pledge.
Scout's promise, taking that pledge. So from my early childhood, I've taken, such an oath of promise, seriously, and then subsequently, when in government. And also my own religious upbringing as well. I might not be that Bible-thumping, practicing Christian, but there are values that I've imbibed. So for me, an oath is a serious pledge that you make and should never be regarded lightly if one has no intention of abiding by it. So this is a point where I felt that I was annoying her by my constant reference to the oath of office. Thank you, Commissioners.
So in that letter, The Minister effectively asked you to advise her in writing. She said, I will appreciate if you can advise me urgently on the matter so that there can be certainty. And as I understand it, that is why you then wrote the fateful memo of 15th of February 2007, which is in your bundle at page 56. If I can ask that we turn to page 56 of your bundle. Which appears to be your response to the Minister. It is quite a lengthy document, and there's much repetition that we have already canvassed. So I will only ask you to read certain extracts, but it's titled Secret Internal Memorandum. It's addressed to Ms. B.S. Mabandla, MP, Minister of Justice, from Advocate Bekoli, NDPP. Subject, prosecution of offences emanating from conflicts of the past, interpretation of prosecution policy and guidelines. It's dated 15th of February 2007. Just for starters, can I ask you to read paragraph 1 titled Purpose of Memorandum?
This paragraph?
Paragraph 1. It's quite a short paragraph on page 56.
On the purpose of the memorandum.
Yeah.
I beg the indulgence of the commissioners. Can I just go back to my discussions with the Minister
Yes.
on the question of oath of office? You know, that's why I was also reluctant to go to the Zodo Commission when I was asked to go. Because I didn't, you know, the pain was still there. You know, on this question, what the Minister actually said to me, apart from expressing her obvious annoyance or irritation, she actually said, I don't know, this obsession with the oath of office. That's my, and I believe it's the correct recollection of what she said, because it pained me. Thank you, Commissioners.
Thank you.
Paragraph 1.
Sorry, just before you get there. So we have a situation where the Minister of Justice puts to you that you have an obsession with the oath of office that you have taken. In suggesting that you had an obsession, what was your reaction to that?
That's why it's so vivid in my mind. I couldn't believe that I could be getting this from not just a minister in the cabinet. All ministers do take the oath, whether it's an oath or an affirmation. But never would I have expected this to be said by a Minister of Justice in constitutional development.
Thank you. All right. Yes, Commissioner.
Mr. Piccoli, that oath of office, I assume, would stem directly from the constitutional guarantees given to the NPA and the NDPP in the Constitution. Am I correct in that understanding?
That is correct, Commissioner. And it is also in the NPA Act. The question of the national director, the deputies, the directors, special directors, you know, All prosecutors have got to take that oath. Because prosecutors are powerful. They can destroy people's lives. You need people who take their work seriously and abide by the requirements of their oath of office. Thank you, Commissioner.
Thank you, Commissioner. Okay, Mr. Picoli, let's then start with reading portions of your 15 February 2007 secret internal memo to the Minister of Justice into the record. Can you start by reading the full paragraph 1 titled Purpose of Memorandum?
Thank you, Commissioners. The purpose of this memorandum is to A, inform the Minister about the National Prosecuting Authority's understanding and interpretation of the policy and guidelines relating to the prosecution of offences emanating from conflicts of the past, which were committed on or before 11 May 1994. B, inform the Minister about the problems the NPA is experiencing in the implementation of this policy and guidelines. And I suppose it's a mistake here, it says B, should have been C. And then to propose a way forward.
Thank you. And then your memo over the following pages deals with background information, which we have already traversed. Paragraph 3, important features of the amended prosecution policy, which we have already canvassed in detail, so we can skip that. And then page 61 is a heading, Problems Relating to Implementation of Amended Prosecution Policy. And we've already just traversed what you have set out there. But can I ask you to read from paragraph 4.4.1 on page 63 through to the end of your memo? And there will be a little bit of repetition, but I think it is necessary to read this part of your memo into the record. So from 4.4.1, please.
Thank you, Commissioners. 4.4.1. Subsequently, on 6 December 2006, the Office of the PCLU received the email marked B from Dr. P.C. Jacobs of the SAPS. Furthermore, the National Director received letters from the National Commissioner and the Director General, NIA, dated 6 February 2007 and 8 February 2007, respectively. In brackets attached here to Annexures C and D, respectively. 4.4.2. According to Dr. Jacobs, his understanding is that the task team must submit a final recommendation to a committee of Directors General in respect of each case. He also points out that the National Commissioner is of the view that this procedure should be followed in respect of each investigation that has been finalized. However, he does not elaborate on the role of the Committee of Directors General. 4.4.3. In his letter dated 6 February 2007, the National Commissioner points out that he has been briefed regarding the meeting of the task team set up in terms of the Cabinet guidelines on the outstanding Truth and Reconciliation Commission, TRC matters. According to the National Commissioner, his understanding is that the officials designated on the task team, in quote, will provide recommendations to the Directors General, who will, as a collective, advise the National Prosecuting Authority as the decision maker of prosecutions, close quote. the Director General, NIA, indicates that he had a discussion with his representative on the task team, and he received a copy of the National Commissioner's letter. He concurs with the views of the National Commissioner. 4.5. In the first instance, it is important to note that as far as the NPA is concerned, this task team was not set up in terms of the amended prosecution policy, which includes the guidelines on TRC matters, but in terms of an internal agreement between the relevant stakeholders. Furthermore, the NPA is not aware of any agreement or arrangement in terms of which the task team must submit a report to a committee of directors general, and which committee must advise the NPA regarding prosecution decisions. Reading the email of Dr. Jacobs and the letter of the National Commissioner in context, it seems as if the above process is a proposal by the National Commissioner and not an agreement reached by the task team. For example, Dr. Jacobs points out that, 1, the National Commissioner is of the opinion, this is in bold and underlined, that it must be established what disclosures were made. The second bullet point, the National Commissioner is of the opinion, again this is in bold, our emphasis, that such process needs to be followed in each case. In the same vein, the National Commissioner writes as follows. First bullet point, we have underlined it and it's in bold, our emphasis, that the complainant be consulted on the basis that the Directors General will have, supposed to have been, an opportunity to provide input before a decision on prosecution is taken. Second bullet point, again it's in bold and underlined, our emphasis. In my view, a comprehensive report should be discussed by the Directors General. Last bullet point, again it's in bold and underlined. Although I do not insist on a meeting of the Directors General after each meeting of our officials, in bold and underlined, I deem it necessary that the substantive reports and recommendations of the officials should be discussed by the Directors General, and again, in bold and underlined, our emphasis, before a decision is made. If I were to go further, 4.6, the NPA cannot agree to the above proposal. The effect thereof might be that the National Director would be obliged, as suggested by the National Commissioner, to wait for the finalization of the proposed process before he may make a decision whether to prosecute or not. If the task team or the Committee of Directors General, in spite of a reasonable prospect of a successful prosecution, unnecessarily delays the process, the National Director would be prevented from complying with the prosecuting authority's constitutional obligation. Therefore, such a process would be unconstitutional. Thank you, Commissioners.
Thank you, Mr. Picorni. Actually, you can carry on reading. We may as well finish all the way to the end.
And then the conclusion and way forward. There is clearly a misunderstanding regarding the role of the task team and the role of the relevant state departments referred to in the amended prosecution policy. In accordance with the approved amended prosecution policy, the NPA is of the view that the duty of the task team or the relevant state departments is to assist the NPA and underline in the execution of its duties. However, nothing prevents such a task team or department whether individually or collectively, to make recommendations to the National Commissioner, provided that the National Director should never be in a position where his constitutional duty is dependent on the recommendation of such a task team or relevant department. Such a procedure would be unconstitutional. 5.2. I've now reached a point where I honestly believe that there is improper interference with my work and that I am hindered and or obstructed from carrying out my functions on this particular matter. Legally, I've reached a dead end. 5.3. It would appear that there is a general expectation on the part of the Department of Justice and Constitutional Development, SAPS and NIA, that there will be no prosecutions and that I must play along. My conscience and oath of office that I took does not allow that. 5.4. Based on the above, I cannot proceed further with these TRC matters in accordance with the normal legal processes and prosecuting mandate of the NPA as originally envisaged by government. Therefore, and in view of the fact that the NPA prosecutes on behalf of the state, I am awaiting government's direction on this matter. Thank you, Commissioners. But I suppose I have to. Yes, sir. I think that I would need to explain myself on this.
Please go ahead.
Thank you. One, this is a letter to the Minister of Justice and Constitutional Development, wherein I'm expressing, as the National Director, my frustrations with the process and the misunderstanding of roles, not of the role of the NPA. The NPA is always clear about its role, with or without the amended prosecution policy. But this misunderstanding arises from the side of the DGs of other departments, that they see themselves as entitled to make recommendations before there can be a decision on the part of the NPA. I do say here that because the recommendation is a recommendation, it's not binding to the person to whom it is made. It's not binding on the person to whom it is made. Yesterday, I spoke of not wanting to even give a whiff that, prosecutorial independence could be sacrificed on the altar of political expediency. This is exactly what I'm trying to convey in this letter, writing to the Minister, that I believe that there's political interference in the work of the NPA. And the NPA Act criminalizes such an obstruction or interference with the work of the NPA. The Minister, in terms of Section 1795, exercises final responsibility over the NPA. That's what the Constitution says. Now, just to also, address this issue when it was placed before my predecessor by Senior Counsellor Vani, when he asked him to sort of comment on this. And I appreciate his reluctance not to want to comment on the positions taken by his successors, which I appreciate. But again, I want to believe that perhaps he didn't have the full sight of what is contained here. When he said that, and also I saw that it was running in the media that Pikoli should have prosecuted. That I did not need, the minister to tell me, how to proceed. I've always been clear that there's no member of the executive who will tell an NTPP on which matters to prosecute and which matters not to prosecute. I've always been clear. And what we have here has always been consistent with that understanding that no one, from the president to the minister to officials, so what I was here, I was like putting the minister on terms, wanting her to state her actual position on this matter. As a cabinet member responsible for the administration of justice, and the Constitution clearly saying that she exercises final responsibility over the NPA. Now here I'm sitting with DGs of departments who have got this position. And as the NTPP, I've got this position. Clearly, I wanted it to come out clearly. Whether she's on the side of the DGs or she agrees with my position. But me acting as the national director is not dependent on that. But I would know that I've got a minister who's not supporting the national director on such an important matter of national importance. Thank you, Commissioners.
Thank you, Mr. Pikoli. So did you actually get a response from the Minister on these deep and serious questions?
No, I didn't get a response.
So you pose these questions in which you say that you've reached a dead end, and you say that there's been improper interference with my work and I'm obstructed from carrying out my functions, that there's a general expectation on the part of the DOJ, SAPS and NEAR that there will be no prosecutions and I must play along. My conscience and oath of office does not allow that. And you get no response from the Minister. What's your takeaway from that?
Saying I was disappointed would be an understatement. I just simply couldn't believe when I give her a detailed report on the post-TRC matters as to what is happening and what is causing the delays. Bearing in mind that here, it was just about one case, which didn't require any further investigations, which she had asked the then acting national commissioner, the acting national director of public prosecution, not to go ahead until the finalization of the guidelines or the amendment of the policy. And then 2006, a decision is taken by the NPA to go ahead. Now this follows the adoption of the guidelines and the amended policy, in which she participated as enjoined by the Constitution to do so. Now, we've got a policy where she concurs with, and there's a problem of even implementing that amended prosecution policy. And I expect as a minister would be able to have a position on the matter. And this was never conveyed to me. Instead, the opposite is true. Now, asking about why are we going ahead, because she thought that you are not going to prosecute on the matter. Thank you, Commissioners.
And just to clear up two matters before lunch, you've pointed out that recommendations are not binding, and indeed they're not. But in this instance, you expected not to act until you had received a recommendation. Is that correct?
Yes, that's the effect of the letter from the National Commissioner. And of course the DG of NIA and the DG of Justice concurred with that position.
Yes. And then lastly, in relation to the reaction of your predecessor, Advocate Belalani and Guka, he said, well, you should have gone ahead. My understanding is that you did go ahead. You didn't stop the prosecutions of the subsequent prosecutions, for example, in the Jucani case, or for that matter, of Commissioner Salebi himself.
That is correct, Commissioners. It speaks for itself, because record will show that even without the response from the Minister of Justice following the letter that I wrote on the 15th of February 2007, the matter, was set down for the 17th of August, and we went ahead and prosecuted in the matter. So I don't know. Also, perhaps my predecessor was not aware of that, but it's on record that we did obtain a conviction, albeit in a manner that I had not wanted. I would have preferred a full trial. But of course, it was at a price. Because as I said, within a month or so, I got suspended. And when I got suspended, and there's a requirement in the law that there has got to be an inquiry following suspension of a national director. And one of the charges I faced was that we went ahead with the post-TRC prosecutions. So, which clearly says, had we not gone ahead, perhaps I might not have been suspended. But of course, there are other reasons that I answered to anyway at the General Commission.
Thank you, Mr. Bakuli. Chairperson, is this an appropriate time for the lunch adjournment?
Yes. We'll adjourn and reconvene at 2 o'clock.
As the Commission pleases.
Mr. Vani?
As the chairperson pleases. Chairperson, Commissioners, I thought it incumbent on me to bring it to your attention that I don't think we'll be able to finish by 4 p.m. with this witness.
Yes.
I think we might struggle to do so. So I just wanted to
Yes.
give you due warning of that.
Yes. Are we able to proceed beyond 4?
We're happy to proceed beyond 4. from our side.
How much time will you require after 4 o'clock?
My estimation, Chairperson, it would be between 30 minutes and an hour
After 4 o'clock?
after 4 p.m.,
Yes, we'll proceed then.
as the Chairperson pleases.
Yes. We'll accommodate you, Mr. Vani.
We're grateful for the indulgence, Chairperson.
We are an accommodating commission.
Yes, I can see that. And given the material we have to get through, I think
Yes.
it's necessary. Mr. Piccoli, I hope you had a relaxing lunch.
I enjoyed the lunch.
Wonderful. I want to refer you to some more minutes from the Justice Portfolio Committee. And this time it was a meeting of that committee on the 3rd of May 2007. And the minutes of the meeting are in your bundle, Bundle 2, between pages 175 and 179. Now, I must apologize in advance that the print is tiny on that page, and I struggle to read it myself. Luckily, it has been reproduced in Bundle 1. If you prefer bigger print, I can refer you to Bundle 1 at page 105, paragraph 250.
I will certainly prefer.
Okay, yes. And for those
On
using
page-
this, so it's page 105, Bundle 1,
Page
at
105.
paragraph 250.
I've got it.
Okay.
Thank you.
For those using the actual minutes, it's at the top of page 178. Those are the passages we will be referring to. So in this committee meeting before the Justice Portfolio Committee, there was a discussion on the TRC cases, and it was quite a long discussion. We don't have time to go through all of it. But let me just put certain extracts to you. Under the heading discussion, one of the members of the committee, Mr. Joubert, asked what was causing the delay in prosecutions.
Are you in 178, Mr. Vani?
Yes, if you are using the
I'm using the small print.
small print, I'm very impressed, Chairperson, that you can read that. So it actually starts, my apologies, it starts at the bottom of page 177, and you will see there's a little
Yes,
italic
I see
heading
discussion.
called discussion, exactly. So under discussion, Mr. Joubert asked what was causing the delay in prosecutions of the TRC and when these might be finalized. And then Advocate Ackerman then gives a response. It's quite a long response. We've traversed those matters, so I'm not going to put all of that to you. But moving on in the quote towards the top of the next page, Advocate Ackerman commented that it was unfortunate that to date no meaningful results had been achieved from these meetings. The annual report of 2006 also noted on page 4 that not much had been achieved, despite all the attempts to take the matter forward. He maintained that the PCLU was not the cause of the delays, and he suggested that perhaps the National Director of Public Prosecutions should comment further. And perhaps I can then ask you to read the next paragraph, where it says Advocate Vusi Pikoli, NDPP added. Do you see that?
Yes, I do.
Yeah.
Thank you, Commissioners. It reads, Advocate Vusi Pikoli, National Director of Public Prosecutions, added that this was a politically sensitive issue. The legal processes must solve the problem. Whenever there was an attempt to charge members of the former police services, there was political intervention, and effectively, the NPA was being held to ransom by the former generals.
Can I ask you just to pause there for a moment? So that is quite a significant statement that you made to the Justice Portfolio Committee. Can you elaborate on what you meant by the NPA was being held to ransom by the former generals?
Thank you, Commissioners. It's been quite evident, given what has been happening from 2004 up until the time we appeared before the Justice Portfolio Committee, particularly on this date, which was May 2007. Nothing much had been achieved. Clearly, this was a political sensitive matter, as can be gleaned from the fact that the President even tabled it before Parliament as far back as 2003 to try to find a meaningful way of attending to these matters. And then all along, there's always been this constant refrain that if you go ahead with these prosecutions, then that is now the prosecution insofar as it related to a specific case at the time, which was the Jucani matter, that this could trigger a prosecution also of the ANC members who were denied amnesty when they applied for it. The 37 ANC members, which included the President of the Republic of South Africa. So clearly, this was connected to that fear. And the reference to us being held to ransom by the former generals, it has already been alluded to that there was this Brits who was in cahoots with the former Commissioner of Police, General Johan van der Merwe, who had their own dossier that contained evidence against ANC members. Therefore, it was clear that there was this constant fear that going ahead with these prosecutions, I wish to remind the commissioners that the prosecution at that time, when it was sort of declared in 2004 and also in 2006, would have been confined to the 3 police officers, Smith, Otto, and Van Staden. But then the co-accused would have joined them in the dock, in the witness stand, would have been now, as of 2007, would have been a former minister of police during the apartheid era, in the name of Mr. Flock,
Yeah.
and also another general, the commissioner, Johan van der Merwe. Now, the stakes were quite high, which I believe then is what also led to the heat being switched on to higher levels, insofar as the NPA not going ahead with the Jucani matter. Thank you, Commissioners.
So in effect, Mr. Pikoli, I suppose the big takeaway is that the former apartheid generals were able to exercise undue influence, not over the NPA because you were standing your ground, but they appear to have influence with senior members of the executive who in turn were placing pressure on you. Is that correct?
It certainly appeared to be so, given the fact that the resistance was largely coming from SAPS in the form of the then National Commissioner, and also supported by the Department of Justice then and the National Intelligence Agency then. But I must hasten to add that also now it appeared to be coming from the executive. Because we should also be mindful that the instruction came from the executive if the submission by Dr. Ramaite is proven to be true and correct, that he received a call from the minister to suspend the prosecution. Thank you, Commissioners.
And then you you mentioned in the same passage, on the other side, the families of the victims were pressing for prosecution. And then let's skip to the next paragraph. The chairperson stated that she was aware of some efforts from the Department of Justice. She asked that Advocate Pikoli provide the committee with a full report on the events to date in writing, so that the committee could try to assist, as this clearly went beyond just the one case cited by Advocate Ackerman. It was undesirable that these problems should still be delaying matters. Did you return to the committee or provide them with the report that was requested?
I'm not aware, given the time, because this was in May. I'm not sure whether there was a report that was specifically prepared between May and the time that we left. But suffice to say that, at least by that time, the portfolio committee was aware of what was happening. And then, of course, in terms of Section 35, the NPA is obliged is accountable to Parliament. And part of that accountability includes the question of submission of an annual report on the activities of the NPA. So therefore, there would have been an obligation on the part of the NPA to give those reports. But as I say, between May and September, I have no immediate recollection of there being such a submission. but also there was some kind of disruption because in July, I had to take, leave because of my mother. And then already, the heat was on in July. July, August. August was the date of the appearance of the 5 in court. And then September, I was suspended. Thank you, Commissioners.
So you were rather overtaken with events which we're going to come to. And we are just checking when the next Justice Portfolio Committee meeting was. But it might have happened at a time when you were, let's just say, indisposed. Do you think that the Portfolio Committee, on hearing of your struggles in relation to the TRC cases and your statement that the NPA was being held ransom by the former generals, that they should have called for a full inquiry at that time?
Commissioners, yes. I would have expected that the Portfolio Committee would have been concerned about the report that you had given them. Because, amongst other things, it was talking about the difficulties that you were going through and the problems of interpretation of the guidelines and the policy. And also alluding to some kind of obstruction, which on its own would have made the Portfolio Committee pay serious attention to that. Because then it would not have been consistent with the law that was passed by Parliament. As lawmakers, obviously they would have been concerned of a possible, because then it would have been coming from our side. But an inquiry then would have proven whether what you were saying as the NPA was true or not. Thank you, Commissioners.
Thank you. And indeed, if there had been a full inquiry back then, perhaps today we wouldn't have been in a need of an inquiry in 2026.
Oh, Commissioners, certainly. It's shameful to say that we were sitting here still trying to find reasons as to why there was no compliance with the law and the Constitution. Perhaps being generous about it, to say at least 2004, here was a clear case that required no further investigations. But the matter couldn't proceed in our courts until 2007, August. The amount of time that has passed from a decision that was taken in 2004, which actually then led to this prosecution, albeit, it's not what we desired, but you were to accept it, given the conditions existing at that time. And after I left, the record speaks for itself. Until then, these matters were subsequently looked at in terms of taking it forward. That passage of time on its own has led to the issues that we have now, finding difficulty in terms of prosecuting because of the witnesses not being there, because of the perpetrators who are no longer there, some of them. It's shameful. Thank you, Commissioners.
Thank you, Mr. Bakuli. Let's proceed with the unfolding story. And for the next tranche, we're going to rely on your 2015 affidavit. And if I can ask you to turn to page 22 of Bundle 2. So you can put aside Bundle 1, bring back Bundle 2. You can go to paginated page 22. And I think we do need to deal with the Jucani case and set out what happened there. And
I'm there, Commissioners.
if I can ask you to read into the record paragraphs 55 to 60.
55 to 60.
55 to 60.
Thank you, Commissioners. During the course of the next few months, the legal representative of Mr. Otto Smith and Van Staden, Frog and Van der Merwe, held detailed negotiations with Advocate Ackerman and members of the PCLU in regard to a plea and sentencing agreement. Paragraph 56. The negotiation of the plea and sentencing agreements with the 5 accused was an extended process and was only concluded in early July 2007. On 10 July 2007, I sent a memorandum to the minister informing her of the fact that the prosecution has been set down for hearing on 17 August 2007, and that all accused had indicated their intention to plead guilty to a charge of attempting to murder Reverend Jucani by means of poisoning. The memorandum informed her of the fact that plea and sentencing agreements had been entered into. To the best of my recollection, the minister did not respond to this memorandum. Paragraph 57. On or about 10 July 2007, I went off on a compassionate leave because of the illness and subsequent death of my mother. In my absence, on 17 July 2007, Dr. Ramayite and Advocate Ackerman were summoned to a meeting with the minister and reported to her on these developments. Paragraph 58. In August 2007, those implicated in the Jucani case pleaded guilty to the charges in exchange for suspended sentences as per Section 105, capital A of the Criminal Procedure Act 1977. Flock and Van der Merwe were sentenced to 10 years in prison, suspended for 5 years, while the other 3 received 5-year prison sentences, suspended for 5 years. I would have preferred a full prosecution in this case. That is paragraph 59. I would have preferred a full prosecution in this case because Adrian Flock and Johan van der Merwe only made limited disclosure. They largely confined their disclosure to facts that were already in the public domain. They declined to disclose detailed information in relation to the compiling of the hit list and who was behind such compilation. They did not reveal the other names on the list, the modus operandi of the other hits, or the identities of the other masterminds and perpetrators. Paragraph 60. A full prosecution in the Jucani case would have produced greater truth and accountability. However, there was strong political resistance to this prosecution and the pursuit of other political cases. It was clear to me that the government, and in particular the then Minister of Justice, did not want the NPA to prosecute those implicated in the Jucani case. This was due to their fear of opening the door to prosecutions of ANC members, including government officials. Moreover, I could not rely on the police to investigate this case and the other political cases thoroughly. Therefore, a plea and sentence bargain was, in my view, the most appropriate compromise in the circumstances. Thank you, Commissioners.
Thank you, Mr. Pikuli. Now, in our consultations, you made reference to a meeting that you held with then President Thabo Mbeki in August or September of 2007. Can you indicate why were you called to that meeting, the main issues discussed, and who was there?
This will not be with direct relevance to the matters, because also at the time, the DSO was dealing with another matter which is not connected to the post-TRC cases. It was a matter that related to the investigation of the National Commissioner of Police.
Can I suggest, just because we are a little short on time, not to go into too much detail, but perhaps you can focus on your request to the President that the NPA be given a political champion to, and I don't want to put words in your mouth, but if you could focus on that aspect of the meeting.
Yes, that would have been a different discussion that I had with the President, with the Minister of Justice in attendance of that meeting. It was a meeting with the President, as I said. In the course of our discussions, I mentioned the fact that the NPA is so much under attack. It was always in the news. The Scorpions were being attacked left, right, and center. The ANC Youth League attacking the ANC. I mean, some of the issues that my predecessor referred to during his term of office. So my point was that the NPA needed somebody who will be like their political champion in terms of the mandate of the NPA, particularly to protect and insulate it from the politics of the day, so that the NPA should be able to focus on its stated mandate, which is that of instituting criminal proceedings on behalf of the state. That's the point that I made in that meeting with the President and the Minister of Justice. The meeting was in Mahlamandlovu.
Thank you. And you made reference to your predecessor, Mr. Nguko. Was he present at that meeting?
Well, when I arrived for that meeting in Mahlamandlovu, I found Mr. Nguka with the President. I don't know the nature of the discussions, but I joined them because I could join them. And we had sort of general discussions, which of course included, these attacks on the NPA, whilst waiting for the arrival of Minister Mabandla to join us in the meeting. That's what happened. And then, of course, Mr. Nguka left. But then, truth speaking, I really didn't have, understanding the nature of the meeting, because then I also had to raise the problems that we were having in terms of the NPA or the PCLU in particular, not being provided with investigators. Thank you, Commissioners.
Mr. Pikuli, can we return to your affidavit, paragraph 23, at least page 23, and can I ask you to read into the record paragraph 61?
Thank you, Commissioners. Paragraph 61. Shortly after the plea and sentence agreement had been confirmed in court a newspaper article appeared in the Rapport newspapers of 19 August 2007, in which it was claimed that the NPA was preparing to prosecute ANC leaders. The claim was made on the basis of a fabricated document. A copy of this newspaper article is annexed here to, marked VPP 4. The NPA responded to this article by way of a press statement dated 21st August 2007, in which the allegations made in the Rapport article were denied. A copy of this press statement is annexed here to, marked VPP 5.
So let's take a look at that report article. It's actually at page 42 of the same bundle. So it's in Afrikaans. It's in the Afrikaans newspaper Rapport. And it's titled Dossiere oor leiers se vergrype lê al jare in kluis. ANC leiers verdwyn. And the journalist is Sonia Carstens. And that is loosely translated. We have provided a Google translation at page 43. Dossiers on leaders' abuses lay for years in safe ANC files disappear. And in this piece is the allegation that the NPA is now going to be taking this matter forward through Anton Ackerman and the PCLU. I don't think there's a need to read that whole article into the record. So let's now turn to what transpired after this article was published. And can I ask you to return to your affidavit on page 24.
I'm there.
And please could you read into the record paragraph 62 to 65.3.
Thank you, Commissioners. Paragraph 62. After the newspaper article was published, I was summoned to a meeting of the subcommittee of the Justice, Crime Prevention and Security Cabinet Committee on post-TRC matters, which was held on 23rd August 2007. This meeting was attended by several cabinet ministers, Directors General, and Mr. Silibe. Cabinet ministers included the Minister for National Intelligence Services, Mr. Ronnie Kasrils, Minister Mabandla, Minister Kweye, amongst others. Paragraph 63. During the meeting, Mr. Silibe said to me that the gloves are now off and that he was declaring war on me, which I took it that he was declaring war also. In response, I told him, for once in your life, can you tell the truth and shame the devil? Paragraph 64. Those at the meeting demanded answers from me about TRC prosecutions. They were also particularly concerned that I was instituting an investigation into certain members of the South African Police Service. This was in relation to my investigation into who was behind the fabrication of the letter purportedly written by Ackerman SC. Minister Mabandla told me to stop this investigation as we could not be seen to be taking each other to court. I advised the minister that I would not stop the investigation. Paragraph 65. I explained that, 65.1, the NPA was bound by law to continue with prosecutions of individuals who did not apply for or who were refused amnesty. 65.2, the NPA was actively preparing for those prosecutions and that we should not be stopped from doing our job. 65.3, it was my role as the NTPP to decide who will be charged. Thank you, Commissioners.
Thank you, Mr. Pikuli. So that meeting really sounded quite emotionally charged, and that there were, and you were now being confronted. Let's first start with the statement in paragraph 64. Those at the meeting demanded answers from me about the TRC prosecutions. They were concerned that you were instituting an investigation into certain members of SAPS. So what answers were they demanding from you about the TRC prosecutions?
You see, with the conviction of Flock, Van der Merwe, Otto Smith, and von Staden, which was on the 17th of August. Now, this meeting is on the 23rd of August, precisely a month before my suspension of 23rd September 2007. Now, obviously, this again brought back the so much repeated lie that the NPA was going to prosecute the ANC 37. Now, to bolster that, there was this letter which was fabricated to strengthen that position that the NPA was hell-bent, excuse my language, on prosecuting ANC members. And over and above that, because I was convinced that this was not true, because it's a matter which was already dealt with during the time of my predecessor. And why it's coming back now, more so after the Flock von der Merwe matter. Here it is coming back. Of course, it's going to trigger those fears on the part of the ANC. And now, when I'm trying to investigate that fabricated letter, I'm being stopped. Because I felt that possibly there's a crime that has been committed, because I believe Ackerman when he said that he did not do that. If ever there was anything, the ministers should have been concerned also as to how did this letter come about, fabricated or not. Now, when I'm instituting an investigation, I'm being stopped. And I felt that this can't be the case. We have to investigate this matter to make, because it was fabricated, and I believe so. Now I'm being stopped. That we should not be investigating one another. Nobody is concerned about how did this letter come about. When, for some time, the NPA, to the extent of even issuing a press statement, that the NPA was not investigating ANC members. So it was a very unpleasant meeting. And obviously, the National Commissioner was very angry that I've instituted this investigation. That's why then he made reference to the gloves are now off. And of course, I did take up the challenge.
But why did you say to the commissioner, for once in your life, can you tell the truth and shame the devil?
It was because I firmly believed that he was telling a lie for such a long time. And people were let me not say people, the DGs of the cluster bought on 28 August 2007. I refer to the meeting of the subcommittee of 23 August 2007, which I considered to be most unpleasant. Despite the information I put before the committee, I'm both surprised and disappointed to see that I now stand accused of misleading, alternatively having lied to the subcommittee members. I confirm that I stand by what I said about the National Commission of Police and the South African Police Services. I confirm and repeat the following: that I have instructed that an investigation be carried out in respect of the forgery of the memo by Advocate Ackerman SC 4.2 as borne by the attached annexure and the numerous communications to the Minister. There is no investigation by the NPA or any of its officials against the 37 ANC leaders, including the President of this country, contrary to the assertions of the National Commission of Police. I give the Minister the assurance that no investigations or decisions to prosecute in these matters are done without my express authorization, as per the prosecution guidelines as they pertain to the post-TRC matters. Whilst I'm not certain as to what the meaning of paragraph 4 of your letter is, it is, however, clear that my account of the position as it relates to the NPA's handling of the post-TRC matters has been completely ignored. Arising from allegations made by 2 police officers, as well as a threat by a lawyer representing former security branch members who were facing prosecution, my predecessor had the material relating to the ANC leadership perused and satisfied himself that there was no basis for the leadership to be investigated. He also briefed your predecessor, as well as members of the Office of the Presidency, to this effect. In my presence and in my capacity as the then Director General of the Department of Justice and Constitutional Development, all the police dockets stored at the Office of the Director of Public Prosecutions, Pretoria, were handed over to the police. These events all took place in early and mid-2004. I confirm as well that the Minister was made aware of all these facts as far back as December 2004, and I'm surprised that this issue is now resurfacing. In view of all that is transpiring now, I request an urgent meeting with the Minister, my deputies, and myself. Further, I request an opportunity to appear before the National Security Council to give a true account of this issue. Thank you, Commissioners.
Thank you, Mr. Pikuli. So, what was the response of the Minister to this letter and your request for an urgent meeting?
There was no response that I can think of.
So, on the 29th of August, you set out in a detailed response to her letter of the previous day. You point out that you considered the meeting of 23rd August with the cabinet ministers to be most unpleasant. You finish off your letter by saying that in view of all that is transpiring, I request an urgent meeting with the minister, my deputies and myself, and further you want an opportunity to appear before the National Security Council to give a true account of this issue, and the minister does not respond to you. What do you make of that?
Well, let's leave it at that in terms of how things were proceeding from that 28th of August, which culminated then to what expired or to what transpired on the 23rd of September. Yes, there was interaction between myself and the minister. We did have discussions. I did receive also another letter from the minister, not necessarily on the TRC matters, but on some other matters. So there was a continued relationship and correspondence to that effect, which again bothered me because they were all about the independence of the prosecutors.
But in relation to the subsequent interactions with the minister, there was no attempt on her part to respond to this letter in relation to the TRC cases.
Yes. Because there was also another urgent matter which related to the National Commissioner of Police. I suppose then that sort of overshadowed everything else, because now the attention was turned to the Scorpions investigation, or rather the TSO investigation against the late National Commissioner of Police, Mr. Siliwe.
Well, let's then turn to the lead up to your suspension, which ultimately happened on the 23rd of September of 2007. And let's start with a letter addressed to you from the Minister of Justice, Bridget Mabandla, dated the 19th of September 2007. And that's in your bundle at pages 93 to 94. So the same bundle 2 at page 93.
I'm there, Commissioner.
And this now touches on the developments around the investigations into the National Commissioner of the Police Service. Can you read into the record the body of that letter, please?
Thank you, Commissioners. Dear Advocate Piccoli, subject, investigations into the National Commissioner of the Police Service. The above matter refers, I'm advised that we have taken legal steps to effect the arrest of and the preference of charges against the National Commissioner of the Police Service. I presume that in making this decision, we have taken time to consider the seriousness and gravity of your intended course of action. As you know, in terms of Clause 1796 of the Constitution, the Cabinet member responsible for the administration of justice must exercise final responsibility over the prosecuting authority. In addition, Section 33(2) of the National Prosecuting Authority Act provides that the National Director of Public Prosecutions shall, at the request of the Minister of Justice, furnish the Minister with information with regard to any case, matter, or subject dealt with by the National Director or a Director. In light of the above, and in order for me to exercise my responsibilities as required by the Constitution, I require all of the information on which you relied to take the legal steps to effect the arrest of and the preference of charges against the National Commission of the Police Service. This includes, but is not limited to, specific information or evidence indicating the direct involvement of the National Commissioner in any activity that constitutes a crime in terms of the laws of South Africa. In pursuing your intended course of action and any prosecution, the NPA must do so in the public interest, notwithstanding a prima facie case. Such exercise of discretion requires that all factors be taken into account, including the public interest. Therefore, I must be satisfied that indeed the public interest will be served should you go ahead with your intended course of action. Until I have satisfied myself that sufficient information and evidence does exist for the arrest of and preference of charges against the National Commission of the Police Service, you shall not pursue the route that you have taken steps to pursue. You should therefore, and with extreme urgency, cause for me to be briefed thoroughly in this regard. Please advise me at your earliest convenience when you, I suppose, and I should expect to receive, when I should expect to receive the necessary documentation. I trust that you find the above in order. Yours sincerely, signed off, Ms. B.S. Mabandla, MP, Minister of Justice and Constitutional Development, date 2007-09-18. Thank you, Commissioners.
Now, you made a response to that letter on the 19th of September, and that's in your bundle at page 271. It's quite a long letter. Let's see whether there is a need to read the whole letter into the record. And given that it is a rebuttal, I think we have no choice but to read it into the record. Before you do so, can I just check whether in your bundle it goes from page 271 to 276?
Yes, it does. 274, 275. I don't have 276.
Let's just get
yes.
you a 276.
276 is missing. Yes, just hand that one in. All right, just given the view of the Minister that she appears to be suggesting that she has a role to play in the exercise of your prosecutorial discretion, I think it is necessary to read the full response from 271 through to 276. Thank you. Thank you, Commissioners. Perhaps before I do that, I beg your indulgence. Again, I believe in context.
Please go ahead.
Thank you, Commissioners. I must say about this specific investigation, I had briefed the Minister. I had briefed the President about 10 times before a decision was taken. When we briefed the Minister about it, she wanted to know exactly what is it. about the National Commissioner in this investigation. Before she wrote this letter, I asked the team responsible for this particular investigation and prosecution to give the minister an idea without compromising on the nature of the investigations and the evidence that was at our disposal. I did this deliberately because I was respecting what the law says in the Constitution, where the minister, if she wants to know what is happening at the NPA and the matters that was seized with, I followed precisely the law in terms of Section 1795 and Section 33 of the NPA Act. We made that presentation to the minister. Her response, I could see that she was scared of this matter, given the full implications of having a national commissioner being investigated and prosecuted. Before that, when I started informing her of the investigation, even before this presentation, I asked her to then, as the cabinet member responsible for the NPA, can you brief the president? She said to me, no, Vusi, you must go. So when I briefed the president, it was because the minister was afraid to go to the president and inform him of this investigation. So when I went to the president, I was on my own, without the minister. But of course, she had said, I must go and brief the president, which I did on not less than 10 occasions. So that's why I was surprised now then when the letter is couched in such a manner as if she has just suddenly become aware of this matter. Having said that, having laid out that context, I'll proceed to read. This is my response to the minister, stated 19 September 2007. Dear Minister, investigations into the National Commission of SAPS. I refer to your letter dated 18 September 2007. I confirm that the NPA had indeed initiated legal steps to effect the arrest of Mr. Silibe, the National Commissioner of SAPS. In fact, as I had reminded you during our meeting yesterday, I had informed you at a meeting on 11 September 2007 that the DSO had obtained an arrest warrant for Mr. Silibe the day before, on 10 September 2007. Request for information and briefing. I assume that the request you make for information regarding the information on which the DSO relied to take this step is made in terms of subsection 2A of section 33 of the NPA Act. I would like to state that I've taken my responsibility in terms of the above section very seriously, given the sensitive nature of the matter. As set out below, I have therefore ensured that you were given extensive reports and information about important developments in the matter. These reports were usually verbal, but were often accompanied by a written report. You had agreed that it was not desirable to leave such reports with you for security reasons. The first preliminary briefing to you occurred in March 2006, when the cable matter was first referred to the DSO, and I've briefed you alone or with others on at least 10 occasions since then. A possible investigation and arrest of the National Commission of SAPS would clearly affect the national interest, and it was vital that the President be placed in a position to take whatever necessary steps to protect the national interest or avoid embarrassment to the country. the outcome of the investigation may necessitate disciplinary or other action against the National Commissioner, and it will be important for the President to know the nature of the allegations. In March 2007, I informed the Minister and the President that Mr. Silibe was formally added as a suspect to the DSO investigation. These meetings culminated in a full and detailed briefing to you by the investigating team of the DSO and myself in the week starting 25 June 2007, which happened at my request and insistence. At this meeting, it was stated clearly that a decision had been made to prosecute Mr. Silibe, and that the DSO was essentially tying up loose ends in the investigation and preparing for an arrest, coupled with a search of Mr. Silibe's residence and the SAP's head office. At this meeting, you raised no reservations about the intended course of action. As a matter of fact, I requested that you seek an audience with the President to apprise him of the intended course of action in the matter. You, in turn, suggested that I should rather brief the President on my own. This gave me a clear indication that you were in agreement with the intended course of action. You are always aware that both the head of the DSO and I had provided a number of briefings to the President, particularly in the period from March 2007 onwards, and requested that I should update the President about the stage reached in the investigation. As you know, shortly after that meeting, I was away from office until early August due to the illness and subsequent passing away of my mother. During this time, the team had essentially completed the investigation. I resumed my efforts to update the President on the latest developments after my return on 6 August 2007, and was finally able to secure such a meeting on 22nd September 2007. But also here there's a 15, so I don't know what was happening. I have always been ready to provide you with a report on this matter, and am ready to do so again. However, I find it difficult to accept the implication in your letter that I have not yet provided you with a full briefing on the matter. Request for information and evidence. With reference to your request in terms of subsection 32(2)(a) of the NPA Act, that I supply you with all information and evidence on which the investigating director of the DSO relied to take action against Mr. Silibe, and the specific information and evidence that links Mr. Silibe to criminal activity. I would like to place the following on record. First bullet point. I believe that the numerous reports and briefings we have given you have dealt fully with this matter. As indicated above, I am happy at any time to give you a further report on the matter. Second bullet point. The most comprehensive summary of such information and evidence was contained in a report produced for the President in May 2007. The Minister of Defense, yourself, and I discussed this report extensively at the time. I enclosed an unsigned copy of this report for your ease of reference. May I point out as well that it is unfortunately not possible to supply you with all the evidence in this matter, realizing what such evidence will severely prejudice the intended criminal prosecution. In any event, the sheer volume of such evidence will make it impractical. I respectfully submit that such disclosure of evidence is not evinced or required by either the NPA Act or the Constitution. A prima facie case and the public interest. The investigating director of the DSO has carefully considered the evidence in this matter as required by the NPA Act. He has satisfied himself that there is sufficient evidence to provide a reasonable prospect of a conviction as required by the NPA prosecution policy. In fact, he is satisfied that there's significantly more evidence than is required to meet this threshold. Given the importance of the matter, Both the head of the DSO and I have familiarized ourselves in great detail with this matter, and we have both satisfied ourselves that this assessment is correct. Regarding the concerns raised about the public interest, I would like to refer you to the prosecution policy of the NPA, which was determined by the NDPP with the concurrence of the Minister as required by Section 21 of the NPA Act and subsequently tabled in Parliament. We have no doubt that the public interest demands a prosecution in this matter. I would like to point out that in all the extensive briefings I've provided to you on the information and evidence available in this matter, we have not once raised any concern that there may not be sufficient evidence to meet the threshold for instituting a prosecution, or that it may not be in the public interest to do so. The only concern we raised initially was regarding the credibility of some potential witnesses, but we were subsequently assured by the extensive corroboration that was found for such evidence. I would like to point out respectfully that neither the Constitution nor the NPA Act contemplates that the minister needs to be satisfied that there's sufficient evidence or that it is in the public interest before a prosecution can be instituted. Such decisions are the sole prerogative of the NPA. Section 33(2)(b) of the NPA Act does provide that to enable the minister to exercise his or her final responsibility over the NPA, the minister can ask the NPA to account for its decisions by requesting it to provide reasons for decisions. That is, once they have been taken. I think that's more.
We'll help you find it. It's
That's-
that
yeah,
small A5 page
Yeah, the
that we
last
go
one,
to.
so it got lost here. Oh, yeah, it is. Thank you. The first paragraph of that page, of that letter. Given the importance of the matter, both the head of the DSO and I have familiarized ourselves.
Are we on the same page, Mr. Vani? Because
Oh.
mine should start with clearly the minister can indicate.
Yes, that is correct, Chairperson. It's just that it's,
Oh,
yes,
okay,
it's the same page.
okay.
It starts clearly. The minister can indicate or even state publicly whether she agrees or disagrees with the particular decision. But I submit respectfully that it is not contemplated that the minister can instruct the NPA to change a decision or not to take it. In this regard, I would also like to refer you to the judgment of the Constitutional Court when it certified the new constitution, where it dealt with this issue extensively. Finally, your letter may be construed as an instruction to the NPA not to proceed with the arrest and preferring of charges against Mr. Silibi until you have satisfied yourself that sufficient information and evidence exist to warrant such steps, and that such a prosecution will be in the public interest. I wish to point out respectfully that if indeed it were an instruction, it would be unlawful. It would place me in a position where I would have to act in breach of the oath of office I took and of my duties under the Constitution and NPA Act. From my interaction with you in the past, I am confident that this is not your intention and that you understand that you and I have a constitutional obligation to protect and promote the independence of the prosecuting authority. I would urge that we meet urgently to discuss this matter and to clarify it. I hope that I've addressed your concerns and, as stated earlier, would be happy to give you a further briefing. Yours sincerely, Lucy Piccoli, National Director, dated 19 September 2007. Thank you, Commissioner.
So you spoke about the oath of office again.
Yes, I did, Commissioner.
I see that.
And on that score, Mr. Pikoli, did you see this as yet another attempt on the part of the Minister to impose her will, or the will of the Executive, on the prosecutorial decision-making of the NPA?
Thank you, Commissioners. You know, in a meeting that we had with the Minister, I was with my deputies. It was in Cape Town. And Mr. Mabanda was visibly angry about these developments. Visibly angry. And you had to go back to Pretoria with my deputies and the head of the DSO. This letter is not my own product. It's a collective product of the NPA that I had to sign off as the head of the NPA. This is the view and the position of the NPA, not my position at a personal level. My position as the head of the NPA, what is contained in this letter. As you can tell now, the wind down. It's the 19th September and was suspended on the 23rd of September. Simple calculation tells you it's 4 days away. Perhaps I must indicate what perhaps I might not have said anyway. I'm not so sure. Not even in my book. That after that meeting and after this letter, 2 things happened. I went back to my office alone and thought hard about these developments. I started preparing a letter of resignation on my own. My deputies somehow came to see me because they could see that I was emotionally, going through a difficult time.
Deputy Dr. Ramaite. Your deputy, Dr. Ramaite.
No, not him alone, with other deputies. Because at the time, the deputies was Advocate Hofmeyer, Willie Hofmeyer. It was Advocate Mshe. It was Dr. Ramaite. It was the head of the DSO, Advocate Leonard McCarthy. So we talked about what is happening. We felt that we were under siege as the NPA. But I didn't go ahead with the letter. That's one occasion. The second one is that I've always had a very good relationship with the late Chief Justice Putupaya Slanga. I went to see him. Because on my appointment, he said to me, should a day come when I consider stepping down or resigning from the NPA, I must have a chat with him. I went to the Constitutional Court. I had a discussion with the late Chief Justice Ngonzo Phaya Slanga and talked about these problems. Perhaps one can accuse me of trying to bring in the judiciary in a matter that does not necessarily concern the judiciary. But at this time, the matter was already with the judiciary, given the sense that we had already applied for a warrant of arrest, and which we obtained from the chief magistrate in Johannesburg. We had applied for search warrants, which matter served before the deputy president of Gauteng in Johannesburg. The matter was out there. And Budpayas, also said that I should not resign. I should just carry on my work. That's why I didn't resign. But I was asked to resign. Thank you.
Thank you, Mr. Pikuli. Let's.
Mr. Vani,
Yes, Chairperson.
I think this might be an appropriate time to take a short adjournment in view of the fact that we are still going to be longer with Advocate Pikoli to give him a short comfort break. We'll reconvene at 3:45.
As the Chairperson pleases.
Yes. Mr. Vani?
As the Commission pleases. Mr. Pikuli, let's now turn to the day that you were actually suspended. And I understand that on that particular day, which of course must have been a very stressful day for you, you had meetings both with Mrs. Mabandla, the Minister, as well as President Mbeki. Now, it does go back many years, but in the Jinwala Commission of Inquiry, you did give an account of those two interactions with the Minister and the President, and I think it would probably be best to refer to the transcript, which we have included in your bundle. It's from page 265 of bundle 2. And my suggestion is that you read certain aspects of that transcript into this record, and then you can add to it if you so wish. It's the transcript of the inquiry into the National Director of Public Prosecutions. That's the 2nd of July 2008. And then at page 265.1, you are being led by your then counsel, Advocate Wim Trengrove, FC. And at the top of the page, in response to a question, you say, "In my mind, I felt that nothing would satisfy the Minister other than stopping the arrest and prosecution of Mr. Selebi." Mr. Trengrove asked, "Did you manage to make an arrangement for a meeting with the Minister?" Could you start reading into the record from your response, and I will indicate to you where I think you can stop.
Thank you, Commissioners. You want me to start from when I respond to...
Yes, it starts, well, the Minister responded to my letter. Yeah.
Well, the Minister responded to my letter dated 19 September, delivered on the 20th September. She responded on the 21st, accepting my request for a meeting. She said that, yes, she was going to see me on Sunday, the 23rd at 5 o'clock. And then Advocate Trengrove, Sunday, 5 o'clock in the afternoon. My response was, in the afternoon, yes. Advocate Trengrove, so did you meet the Minister on Sunday afternoon at 5 o'clock? Pikoli, we met shortly after 5 o'clock, not exactly. What happened at that meeting? Well, we exchanged the normal pleasantries, we chatted a bit, and then got to the core issues, which I thought were the core issues of the meeting, because I was ready to engage the Minister in the discussions around her request. The Minister said to me, "Vusi, I want you to resign." I asked the Minister, "Why, Minister?" The response was that there is a breakdown of the relationship of trust between the two of us. I said, "But Minister, you know as much as I do that there is no breakdown in the relationship of trust between the two of us." She did not respond to that. She said, "Vusi, it's all about trust." No, it's all about integrity. I will talk one day. Advocate Trengrove, it's all about, then intervenes Pikoli. She went on further to say that she feels bad that during her time in office, she had to ask 2 national directors of public prosecutions to resign. Advocate Trengrove.
If we can just pause there for a moment, would I be right in saying that the other national director of public prosecutions she asked to resign could only have been Advocate Bulelani Nguka?
It stands to reason to believe so, because he was the first national director of public prosecutions. I followed him.
Can you repeat that? I didn't hear because of the noise.
And my response is that, yes, it stands to reason that it would have been Mr. Ncuka, because he was the first national director of public prosecutions, and I succeeded him, therefore becoming the second national director of public prosecutions.
Thank you.
Please continue.
Advocate Trenkov, she said it's all about integrity. Pikoli, yes. Trenkov. And then one day, Pikoli, I will talk. I don't know what she meant by that. I didn't take it further on that. I did not ask her as to what she meant. Trenkov, suggesting though that you don't know the full story. Yes, or Pikoli, yes. That you know there might be a need to explain some other time as to why she had to take whatever course of action that she was taking. Trenkov. And then what happened? Pikoli. We also talked about our communication during the week, including the telephonic conversation where the minister broke into a tirade, and she again apologized for that because I was seriously hurt by that, because she made a serious allegation. She accused me of being disrespectful to her. Now, given my upbringing, what my mother taught me and my father, sorry.
Mr. Pikoli, if you wish, you can skip that section.
Thanks for the offer, but thanks for the offer, but I have to read it. Excuse me. Now, given my upbringing, what my mother taught me and my father, I felt that she was insulting the memory of my mother. I was hurt and angry, and I told her so. She apologized, and I accepted her apology. Trenko, are you okay? Would you like to have some water? Yes, I'm fine. Trenko, did she go on at any time to explain what she meant when she said to you it's all about trust, or there has been a breakdown of trust? Pikoli, no, she did not. She did not explain herself further. Trenkov, did you believe that there had been a breakdown of trust between the two of you? Pikoli, no. Trenkov, did you in fact in that meeting experience any lack of trust between the two of you? Pikoli, no. Trenkov, was there anything else during that meeting, or was that it? Pikoli, well, after that meeting, I had to prepare to have a meeting with the president. Excuse me. So we parted. Excuse me.
If we can just pause there for a moment, Mr. Pikoli. Before we move on to the subsequent meeting with the president that evening, in our consultation, you mentioned a little more of what went on in your meeting with the minister after she asked you to resign. And you said that there were 3 reasons why you could not resign. Perhaps you can just elaborate on those.
Yes, that is correct, Commissioners. I said to Mr. Mabandla, no, I'm not going to resign. And I'll give you 3 reasons, which I thought of them on my feet, on the spot. I said to her, 3 reasons that I would be lying to the nation and to myself if I were to resign, because I won't be in a position to state the real reasons behind that resignation. I would have to say, I've decided to pursue another interest in my life, and I've decided to leave. But given the short tenure, I was appointed in 2005, and by 2007 already I'm thinking of other things. So I said, I will have to lie, not only to the nation, but to myself. I'm not prepared to do that. Secondly, for the sake of independence of the prosecutors, it can't be right for a member of the executive to ask a national director of public prosecutions to resign. Thirdly, for the sake of rule of law, if I've done anything that is wrong, let there be due process. And that due process obviously then translated itself into the General Commission. Thank you, Commissioner.
Thank you, Mr. Pikuli. So perhaps you can pick up where you were about to start with the meeting with the President. You'll see that
Trenko, your meeting with the President was arranged for 7:45 that night. Pikoli, that is correct. Trenko, who attended the meeting? It was Reverend Jucani and the President. Trenko, could you tell us what happened? Pikoli, when I got into the meeting with the President and Reverend Jucani, perhaps let me, if I'm allowed to, go back to the meeting of the 23rd with the Minister, the earlier meeting with the Minister. The meeting that afternoon, the Sunday afternoon, and then Trenko, the meeting that afternoon, the Sunday afternoon with the Minister. And then I said, Pikoli, the Sunday afternoon meeting, in response to the Minister, I had said that I'm not prepared to resign for 2 reasons, because of the rule of law and the independence of the prosecutors. And furthermore, I indicated to her that I would be lying to the nation if I were to resign, because on being asked, I would have to say that I have resigned voluntarily, when in fact this would have been imposed on me by somebody else to resign. I said, for those reasons, I'm not going to resign. So when I met the President later that evening, the President informed me that the Minister has already briefed her on my discussions with her. That is my earlier discussions with the Minister, and that I've refused to resign. I confirmed that to the President. I said, yes, Mr. President, I refused to resign. And I told the President why I refused to resign. I gave the President the same reasons that I gave to the Minister. One, on the rule of law and the independence of the prosecutors, and also that I will be lying to the nation if I were to resign, because I will have to make it out as if it was a voluntary decision. The President then said to me, Vusi, this is all about interpretation. There's life after this. Do you think if I were to give you a letter of suspension, you would not change your mind? I said, no, Mr. President. I will accept your decision to suspend me if that is your intention. And then the letter was prepared in my presence, the letter of suspension. I remained with the President in the room whilst Reverend Jucani was organizing the letter to be ready for signature by the President. And then I asked the President, Mr. President, can you please tell me, why are you suspending me? The President said, Vusi, it's all about interpretation, and also it's all about the plea bargains. Trenko, could you just repeat that? I lost the first sentence. The President said, Pikoli, well, the President said, Vusi, this is all about interpretation and also about the plea bargains and you entertaining the possibility of granting immunities to criminals. My response to the President was that, Mr. President, I think you are rather skating, should have read that, but the transcription doesn't say so. I think that you are rather on thin ice because these issues that you are raising touch on the core competence of the NPA. We left it at that. And then the Reverend Jucani brought the letter. The President signed the letter. It was put in the envelope and I was given the letter. And then I left the residence. Trenko.
Let's, before we deal with the next section, we'll come back to it shortly. I think we should now turn to the letter and then we'll come back to the transcript. The letter is on page 90 of the same bundle. And my attorney advises me that if anybody needs a clearer copy, we do have copies, a clearer copy of this letter. This is a photocopy from Mr. Pikoli's book. So this is a letter from the President to Advocate Macaulay, dated the 23rd of September 2007. Mr. Macaulay, will you read the letter into the record?
Thank you, Commissioners. Dear Advocate Piccoli, as you are aware, the prosecuting authority forms an important part of our criminal justice machinery and accordingly our fight against crime. This machinery to fight crime was further strengthened in 2000 when Parliament adopted legislation creating the Directorate of Special Operations, DSO, in the Office of the National Director of Public Prosecutions. In recognition of the particular threat posed by organized crime in the country, the DSO was specifically tasked to investigate and institute criminal proceedings relating to organized crime activities. As a result of the importance of the prosecuting authority to the success of our fight against crime, I receive regular reports from government agencies and ministries about the activities of the authority. Organized crime poses a serious threat to our national security. Whilst I accept that the prosecuting authority has the discretion to enter into plea bargain and immunity arrangements with alleged offenders, the public interest must always be considered. Accordingly, in determining what is in the public interest, before exercising such discretion, the prosecuting authority must necessarily have regard to the totality of information available to the state. Such plea bargaining and/or immunity arrangements cannot be done at the expense of our national security. Clause 1796 of the Constitution of the Republic of South Africa provides that the cabinet member responsible for the administration of justice must exercise final responsibility over the prosecuting authority. Accordingly, the government, on his behalf, the Minister of Justice and Constitutional Affairs, exercises this responsibility, must and does have an interest in ensuring that the prosecuting authority serves the public interest. In this regard, acting in terms of the dictates of the Constitution, the Minister of Justice and Constitutional Affairs informed me about some of the matters that the national prosecution was seized with. Some government agencies also advised me of some of the activities relating to the same matters. The information I received shows that you have entertained the granting of immunity to members of organized crime syndicates in instances where the prosecution of such people would, in the government's view, be in the public interest. In some of these matters, there seems to be no reason why the prosecuting authority would not proceed against all persons implicated in the alleged offenses. I have evaluated the information at my disposal and have reached the conclusion that you, in your capacity as National Director of Public Prosecutions, have failed to appreciate the nature and extent of the threat posed by members of organized crime syndicates to our national security. Such a lack of appreciation in itself amounts to a threat to our national security. The Minister of Justice and Constitutional Affairs has also drawn my attention to the breakdown of relations between your office and hers due to several incidents, such as your testimony to the Khampempe Commission of Inquiry. Accordingly, this letter serves to inform you that I, acting in terms of the provisions of Section 12(6) of the National Prosecuting Authority Act, the Act, have decided to suspend you from office with immediate effect. You will continue to receive your full benefits during the period of suspension. Acting in terms of the same provisions of the Act, I have also decided to institute an inquiry into your fitness to hold the office of National Director of Public Prosecutions. The particulars relating to the inquiry will soon be communicated to you. Yours sincerely, signed, Thabo Mbeki.
Thank you, Mr. Macaulay. So I'd like you to give the Commission your views on this letter and in particular the claim by President Mbeki that various decisions you were taking as NDPP amounted to a threat to South Africa's national security?
Thank you, Commissioners. One, the work of the NPA, the constitutional mandate of the NPA. The NPA Act talks to the NPA instituting criminal proceedings on behalf of the state. And perhaps this might also lead us to go back, particularly when it came to the question of an approach to issues of national unity and reconciliation. When it was said that, when President Mbeki said that the NPA must deal with these matters, but assisted by the intelligence agencies. What I would find strange is that throughout that process, before coming to to the issues raised here, once did those responsible for our national security. And when I refer to national security services, this is in Chapter 11 of our Constitution. And that chapter, 198, talks about our approach to issues of national security, freedom from fear and freedom from want. But then the specific security services relate to the Defense Force, to the South African Police Services, and to the National Intelligence Services. If we engaged in any work that could pose a threat to national security, there was enough opportunity for those responsible for national security to put this matter at the disposal of the NPA, particularly the National Intelligence Services. Without being long, I said yesterday that Minister Dala Omar, when he was Minister of Justice, was also Minister of Intelligence Services in the first administration, and I was his special advisor. Actually, today is the day that he passed on, the 13th of March. May his soul rest in peace. I owe that man a lot. So, to the extent that he, together with the Deputy Minister of Intelligence at the time, Comrade John Tlantla, asked me to chair a ministerial inquiry into the work of the intelligence services, which means that I had a good understanding of intelligence services. And that understanding also tells me that intelligence services, amongst other things of the collection and processing and analyzing information, they are the only intelligence service that has got a national legal mandate for counterintelligence in this country. Now, counterintelligence is there to counter the threats to our country, so far as national security. Not once was this information placed at our disposal, which would obviously would have given us a fuller picture on some of the issues. And then our decision would clearly would take that into consideration without necessarily fettering our discretion in terms of our mandate about who had to be prosecuted or not prosecuted. And secondly, the reference to issues of plea bargain and granting immunities in terms of Section 204. of the Criminal Procedure Act. I engaged with the minister, with the president, when I had asked him. I might not have said everything there, but it was amounting like the president saying to me that, you guys at the NPA are prosecuting people that we think should not be prosecuting, and actually you are prosecuting people that we think you should, That's why there's a reference to skating on thin ice, because this is the sole prerogative of the NPA. And even if we are wrong, and if I were to be more specific, one, our matters where we've taken a decision to prosecute end up in court. We lose cases, we win other cases. But there's nothing that should prevent the NPA from taking a decision to prosecute, whether we are going to win or we are going to lose the matter. That has always been the position of the NPA and me. And also, us having gone to the courts for the warrant of arrest, because there's a further assurance, because whoever would be presiding over the application for a warrant of arrest would have satisfied himself or herself. More so when it comes to the application for search and seizure warrants. And in this case, I must indicate that I think it was Justice Phineas Muchapelo, before whom the TSO appeared in his chambers, who gave them a hard time in terms of him having to be satisfied that indeed, in this particular instance, it warranted the issuing of such. That's another level of assurance in terms of our work. And then, of course, there are the courts. It's not a responsibility of the executive, because our decisions are always a subject of criminal trials. So that's why I said to the president that, Mr. President, you are skating on thin ice on these issues, because we should be allowed, and the law says we take decisions. So this was the nature of our discussions with the president on that evening.
Thank you, Mr. Picoli. And just to round up on the transcript, can I ask you to go back to page 268?
268.
268, yeah.
Yes, Commissioner.
And I stopped you in the middle of the page where Advocate Trengrove says, will you have a look at the letter, please? Can you read
Yes.
the record from there? And I will stop you when you get to a point on page 269.
Thank you, Commissioners. Trengrove, will you have a look at the letter, please? It is VP1. He says on the first page, in about the 5th paragraph, organized crime poses a serious threat to our national security, whilst I accept that the prosecuting authority has the discretion to enter into plea bargain and/or immunity arrangements with alleged offenders. The public interest must always be considered. Accordingly, in determining what is in the public interest before exercising such discretion, the prosecuting authority must necessarily have regard to the totality of information available to the state. Do you have any quibble with that paragraph? Picoli, yes, I do have. I can never imagine anything more in the public interest than investigating the chief of police when there are allegations of him being in the books or in the payroll of organized crime. I don't think there's anything more in the public interest than ensuring that you fully investigate those serious allegations, and if satisfied that there is a case to be met, to charge the National Commissioner. Trencove. The President said, he quotes, such plea bargaining and or immunity arrangements cannot be done at the expense of our national security. Did you believe that you had entered into plea bargain or immunity arrangements at the expense of national security? Pikoli, no. Trencove. Over the page.
I think we can stop there, Mr. Pikoli. Unless you have anything to add to the interactions with the President, we can move on.
Yes, I know, obviously. What it did fell within the four corners of the law. Plea bargains, Section 105, capital A, and Section 204. It's part and parcel of our legislative arrangement. And these are processes that the NPA, in the normal course of things, will have to invoke in appropriate cases. Therefore, I didn't see any threat, to national security.
Indeed. And as we heard from earlier evidence, we will see that some of the complaints also related to the TRC cases, and in particular the plea bargain relating to the Jucani case. And again, the accusation was that you hadn't taken national security into account. Is that correct?
No. On the Jucani matter, at the time it happened, nobody ever put anything around national security.
Yes. Well, when we get to the Jinwala Commission proceedings, it will be raised there.
Yes.
Yeah. I'd like you to read into the record your concluding paragraphs of your 2015 affidavit. So if you could then turn back to page 28. Could you read into the record paragraphs 75 and 76?
Conclusion. Paragraph 75. I have little doubt that my approach to the TRC cases contributed significantly to the decision to suspend me. It is no coincidence that it has not been a single prosecution of any TRC matter since my suspension and the removal of the TRC cases from Advocate Ackerman. Paragraph 76. The political interference or meddling that I've set out in this affidavit is deeply offensive to the rule of law and any notion of independent prosecutions under the Constitution. It explains why the TRC cases have not been pursued. It also explains why the disappearance and murder of Nokuthula Simelane was never investigated with any vigor, and why the pleas of her family and her representatives were ignored.
Thank you. And indeed, that affidavit, which is dated 6 May 2015, am I correct in saying that that was a supporting affidavit in support of Tembi Simelane, then known as Tembi and Karameng, in an application that she brought before the High Court to compel a decision in her sister's case?
Yes, this is correct, because I deposed to that, which was part of the proceedings.
Yes, indeed. And I want to turn to the Jinwala inquiry into your fitness to hold office. And in particular, I want to refer to the government submissions dealing with the TRC cases. And that's at page 180 of the same bundle.
I'm there.
So as you can see, this is titled Submissions of Government to the Inquiry into the Fitness of Advocate Vusumuzi Koli to hold the Office of National Director of Public Prosecutions. And if we can turn to if we go to paragraph 212, that's at so it's page 212, and there's a section titled Post-TRC Litigation. Quite a lot is said here, so we only have time to deal with some of the extracts, but can I refer you to page 213, and let's start at paragraph 119. We can deal with them in tranches. I'm going to read the first two paragraphs, 119 and 120, and seek your response. Shortly after its establishment, it became clear that the task team was not operating as efficiently and effectively as envisaged by the directives. Members of the task team from outside the NPA were continually frustrated by the officials of the NPA who denied them access to files in respect of cases under consideration, but elected to provide the members with summaries of cases. This compromised the task team's ability properly to consider issues and make informed and appropriate reports to their principals. As a consequence, critical information relating to crimes arising from conflicts of the past was not presented to the Directors General represented in the task team. Paragraph 120. These concerns were raised with the National Director. Effectively, the NPA proceeded to evaluate these matters without the participation of other members of the task team. This despite confirmation by the National Director in the meeting of 12 October 2006 that the committee will make recommendations to him on each case. So, Mr. Pikoli, it seemed that from the side of the government, they were expecting not just summaries, but perhaps your entire files, the dockets in question. Were they entitled to get these dockets?
No, Commissioners.
And do you have any other response to those two paragraphs?
Trying to be short, no. I agreed with the approach taken by the NPA.
And then in the next paragraphs, 121 and 122, which I will try to paraphrase if I can, this is where there's the claim that your handling of these cases were impacting on national security. So the post-TRC cases are of great importance to the government and the country, yet this is an area of dispute between the NPA and the other departments in the JPS cluster. The effect of this disagreement is that the issues were not properly discussed with the cluster, notwithstanding their profound potential impact on the national security of the Republic and the objective of national reconciliation as set out in the interim constitution and the TRC Act. Next paragraph. An indication of the problem arose when the NPA concluded plea bargains with Mr. van der Merwe and others, the Flock matter. This matter was not discussed in the committee as was intended prior to the final decision of the National Director. The Minister was also not informed of the plea bargain until after they were made. And if you just jump to the last line, this failure to discuss the matter resulted in national security issues not being reflected on in relation to the matter. Your response?
Thank you, Commissioners. My single response to this. It's not incorrect. First, you must remember that these were put to me as a charge during the Ginola Commission, a government submission. to justify the holding of the inquiry. When I responded to this, the charge was withdrawn. Because I would have gone on to point out certain issues that actually happened and issues or things that did not happen. Because it is indeed true that there were all these different interpretations, and knowing the mandate of the NPA, we were quite clear that there's nothing that prevents us from going ahead with the prosecutions. I suppose perhaps now would be the opportunity, for instance, for those who represented the government at the time and those who prepared the submissions of government, which obviously would have been the DGs of the cluster, particularly SAPS, NPA, and NIA, who have played a major role in these submissions. And these are the people that we didn't see eye to eye in terms of what was required going forward on these matters. Perhaps it will be the right appropriate for those who made the submission to also perhaps explain as to why did they have to withdraw this charge against me when I was prepared to respond to all the allegations that are contained in the submission. Thank you, Commissioner.
Do you have a sense, Mr. Bikoli, why they decided to withdraw this particular charge?
The only thing, Commissioners, that perhaps I can say is that they knew that they would not have been able to sustain the charge. Truth be told, they would not have been able to carry on with this charge. And to save them from embarrassment, that would have resulted in my response to the allegations. Well, the best decision is to withdraw the charge. So the matter is not fully ventilated before the General Commission.
And then the last two paragraphs, 123 and 124, along the same lines. The complaint is that notwithstanding a meeting of the relevant DGs with the National Director, that the matters be thoroughly discussed before the National Director made his final decision.
Where are you, Mr. Vani?
Oh, sorry, I'm in paragraph 123.
Paragraph 123, yes.
23 on page 215. So the complaint is that the DGs couldn't discuss this matter before you made your final decision. And so that issues that needed to be taken into account couldn't be, including national security. And then lastly, 124, and I'll just focus on the middle sentence. The National Director failed to honour this directive by including plea bargain agreements with Mr. Van der Merwe and the others before informing the Minister of these agreements. My recollection is that you went out of your way to inform the Minister before the conclusion of the plea and sentence agreement in court.
The commissioners will recall that there's a letter or memo that was sent to the Minister of Justice on the 10th of July, 2007, informing the Minister of the position that we had taken, that the matter was set down for the 17th of August, 2007.
Now, there's another affidavit that's before the Jinwala Commission, and that's the affidavit of the Minister herself, Minister Mabandla. It's also in this bundle at page, it runs from pages 227 to 257. But it's quite late in the day, Mr. Pacoli, and I don't see anything really different between her submissions and that of the government. But if there's anything in particular you would like to respond to, you may do so.
No, Commissioners. All the issues, I think, I'll be repeating myself if I were to respond to the, arguments made in this affidavit, because I think that I sufficiently responded to these matters.
Yes, thank you, Mr. Pacoli. Then let's turn to the finding of the Jinwala Commission, which is at page 258 of the same bundle. This is the finding of the report of the inquiry into the fitness of Advocate VP Pacoli to hold the office of NDPP. The report was issued in November of 2008. There's a section dealing with the post-TRC cases, page 259. Let me just see if there's anything in particular that we should deal with. The chairperson of the commission ultimately noted that this complaint had not been pursued further. If I can draw your attention to paragraph 211. And can I ask you to read into the record from the middle of that paragraph? There were concerns articulated by the DG about the nature of the consultation, to the end of that paragraph.
Okay. There were concerns articulated by the DG Presidency about the nature of the consultation, but for the purposes of this report, it is unnecessary to deal with those, save to say that he found the demeanor of the prosecutor insensitive to his plight as a victim in that case. This complaint also touches very closely on the constitutional guarantee of independence of the NPA to prosecute or not to prosecute, and to do so without fear, favor, or prejudice.
Do you think it's significant that that commission found it necessary to highlight the fact that this complaint touches on the constitutional guarantee of independence of the NPA?
Commissioners, it did.
And perhaps you can just read the last line of paragraph 213 on page 261 into the record.
Paragraph 213.
Yes.
Moreover, government has not pursued this complaint. In closing argument before the inquiry, it was stated on behalf of government that the TRC and Khampempe we have not gone into. We have not pursued the TRC complaint and the Khampempe complaint. As a result, it is my considered opinion that the government has not made out a case that Advocate Pacoli is not fit for office by reason of this complaint.
Thank you. Now, before we close up, just a few matters we have to deal with.
Perhaps before that, with the indulgence of the chairperson and the commissioners, just perhaps before you proceed, something which, I'll be short, something which came up on TV yesterday, and also which formed part of the allegations. It has got nothing to do with the post-TRC cases, but it has got a lot to do with the independence of the NPA. Advocate Mutibe, yesterday, spoke of the NPA going flat out for financial and administrative independence. And it's one of the charges that I faced at the General Commission. And I want to commend Advocate Mutibe to have carried on what I became victim of. And indeed, it is required. And I fully support, and I hope Parliament will also support Advocate Mutibe in his endeavors to have the NPA declared a public entity in terms of the PFMA Act. I faced an allegation, a charge, because we were making moves towards the financial and administrative independence of the NPA. I'm sorry to have raised this issue, which has no direct bearing, but it's relevant.
Yes, indeed. I think it most certainly is relevant, and thanks for raising that, Mr. Pakuli. So just a few other matters. We promised to bring to the attention of the Commission when the next Justice Portfolio Committee meetings were held. After the meeting, which was, I believe, in my team will tell me, that meeting where it was indicated that the NPA was being held to ransom. I think it was in...
should have been in May 2007.
It was in May 2007. So my team have discovered that there was another Justice Portfolio Committee meeting. I'm not sure if the date is correct. It says the 8th of May 2007, but that was in relation to the Commission for Gender Equality. Then the next meeting that dealt directly with the NPA was only held a series of meetings between the 20th and 26th of February 2008. And of course, by then you were no longer in the NPA, you were on suspension. And in those meetings, the TRC cases were not discussed. Then I want to give you an opportunity to respond to various allegations that Advocate Menzi Simelane has made against you in his affidavit filed before this commission. And we have put up Mr. Simelane's statement in this bundle. It's at page 277. I don't want to take up too much time, given that it's already 20 to 5, but I want to put certain of his allegations made against you so that you have an opportunity to respond. Firstly, Mr. Simelane claims that while he was Director General of the Department of Justice and co-chair of the DG cluster, while you were DG of Department of Justice and co-chair of the DG cluster, you penned a memorandum motivating for the dissolution of the DSO.
On which page are you, Mr. Vani?
So this is paragraph 24 of Mr. Simelane's affidavit. My team will find the the page number, the paginated page number in bundle 2.
Paginated 285.
Yes, that's correct. So, Mr. Pikuli, what is your response to the claim that while you were DG of Justice and co-chair of the DG cluster, you penned the claim that you penned a memo motivating for the dissolution of the DSO?
Commissioners, this would not have been within the personal knowledge of Advocate Simelane, because at the time he was not the DG of Justice.
No, it's when you were DG of Justice.
No, I'm saying when he made this,
All right.
he was the DG of Justice. What I'm saying is that this would not have been within his personal knowledge, because he's referring to my term of office when I was DG. Advocate Simelane was appointed after I had left the Department of Justice. So it's something which he would have been told by the DGs of the cluster. So it didn't fall within his own personal knowledge. That's one. And two, I did express my position even when I was the DG of Justice on this matter. But for him to say that, first I reject this, and I would want to put him to the proof thereof, about me having penned a memo, which obviously must be lying somewhere, and which I think should be unearthed. Because my position also at the Kambembe Commission, the first Kambembe Commission, contradicts this position. And it's also one of the charges that I faced at the Chinwala Commission, that there was this disagreement between me and the Minister of Justice at the Kambembe Commission. Because at that first Kambembe Commission, I defended the position of the DSO. Hence also this reference, I think in the letter of my suspension from the President, that also one of the things would have been the disagreement between me and the Minister when there was the Judge Sisi Kambembe Commission, the first one. So therefore, what he's saying is not borne by fact. And perhaps it would be good if we were to produce such.
So you're saying what's there is wrong.
Pardon?
You're saying what's there is wrong.
I'm disputing it, and I'm putting him to the proof thereof.
And then in the same paragraph 24, Mr. Simelane claims that other DGs in the GG cluster knew you from the time that they grew up together in the same area in Gqeberha.
Again, this is not correct. At the time, none of the DGs of the JCPS cluster grew up with me during this period.
And then Mr. Simelane claims...
Just to be sure, but also I don't know in terms of the relevant periods. The only person also who's older than me who became a national commissioner would have been Commissioner Lindamti, who was a DG. But during the relevant period, this can be checked and ascertained. I don't think it was part of the cluster at that time.
Yes. And then in paragraphs 26 to 28, which is at page 286 of the bundle, Mr. Simelane claims that you attended a DG cluster meeting with Advocate Ackerman.
If this is a reference to the Jesus cluster when I was the national director, I didn't attend meetings of the GCPS cluster when I became the national director. And I wouldn't have gone with Advocate Akameni as it is intimated here. Because obviously, if he says that, I attended a meeting with Advocate Akameni, it can only be when I was the NTPP. Because it's only then that I would have had the authority to ask Advocate Akameni to accompany me to the meetings of the DGs.
And am I correct in saying that it was the traditional custom that NDPPs would not attend DG cluster meetings?
Firstly, at the time of my predecessor, Mr. Nguga didn't attend meetings of the JCPS cluster. I did not attend meetings of the JCPS cluster. But later, when I got back to government, I realized that the NTPP or the NPA would be represented in the meetings of the cluster. But this was after my period.
Okay.
But then, when I got back to government, particularly when I was the special advisor to Minister Mkhunu and then to Minister Kachalia, it's when that I saw that actually things have changed.
And at paragraph 35, which is page 288 of the cluster, of the bundle, Mr. Similani claims that the cluster meeting referred to descended into disorder. Your response?
I have no recollection of any meeting of the cluster that descended into disorder. Yes, there were, disagreements, and strongly so, but not to the extent of a meeting having degenerated to such levels.
And then if you turn to paragraph 37, which is also on page 288.
I'm sorry,
Yeah.
Commissioners. Well, I think it was most around the time when there was this demand to remove Anton Akamen from dealing with matters of the post-TRC matters. And I stood firm. All the DGs felt that he should be, removed from these matters. I think this was a reference to that particular issue.
And then if we turn to paragraph 37, which is also on page 288, Mr. Similani claims that the Political Military Council was discussed at the cluster meeting. Your response?
The Political Military Council.
I think he got the name mixed up. I understand it's actually the Political and Military Committee.
Well, yes, the structures in the ANC at the time would have been the structure of the Political and Military Committee, which was known as the PMC. I was not part of the structure even when I was in exile. I would not have known the people there. And also, I never had a peep even, in those dockets that were since taken to SAPS, basically, when my predecessor, was angry and ordered that they be taken there. It was when I became the NTPP, I felt that there was no need for me to open something which, the NTPP had decided on, and I didn't feel there was any urgent need to try to review his decisions. So for me, the matter was closed. Yesterday, I made reference to the Congress issue.
So, to your recollection, what was the PMC discussed at that cluster meeting?
No, as I say, I didn't attend, meetings of the cluster, so I would not have known whether there was a question of the PMC which was operating during our days in exile.
And then also in paragraph 37.
And also I believe that since I've never known him to be a member of the ANC. Perhaps when he came back he was. And I'd never had any association with him in exile, whether as a member of MK or an ordinary member of the ANC. But I can't rule out that he was a member. But I don't think he would have been privy to issues relating to the PMC, other than hearing from some DGs of the cluster.
And then also in paragraph 37, Mr. Similani says that he was present when Ackerman was said to have stated that he will prosecute one member of the liberation movement and then one from the apartheid security forces.
Commissioners, I think we've dealt with this issue because it all revolves around Anton Ackerman, and the fear being that once you start with the prosecution against former generals, and then what was going to follow would be the prosecution of ANC members. And again, this was further emboldened by that forged letter, actually, which sort of now was saying, here we told you, here's this thing that the NPA has been denying all along.
And then if we can turn to paragraph 39, which is at page 289, Mr. Similani claims that you acceded to the demand of the DG cluster, and I quote, that if the members insisted on the removal of Ackerman from the TRC cases, then he will remove him, but that he will seek his counsel anytime if he needed it.
No. The issue here is that also, I did earlier indicate that I had to choose my battles tactfully. I didn't want to cause any further delays, but I never removed Anton Ackerman from the cases. But what I did, so that I'm able to eliminate this obstacle, Ackerman, and also knowing him to be, abrasive and can, cause, friction, because, a hardcore prosecutor can cause that. And I regard him as such. Tactically, for things to proceed, I said, fine, Dr. Ramaite, to whom he reported, would attend those meetings, and will be the one who takes a lead in the discussions, so that it's not Anton who is the face of the post-TRC prosecutions, because that animosity would have continued and would have caused further delays. So I never removed him, because anyway, I didn't have any authority, because he was a special director appointed by the president.
And
sorry,
yes,
you say this obstacle, Ackerman, you show in quotes, this obstacle, Ackerman, did you do that? Isn't it? In quotes.
Yeah.
I mean, as you were sitting there, I was looking at you.
Yes, Commissioner.
I'm merely putting the record straight, because the record would show that it's not you who say it's an obstacle.
Because he was seen as the obstacle, and I didn't believe that he was an obstacle.
Yes.
So that's why I was saying this obstacle, meaning that it's not me saying that,
Yes.
that he was an obstacle, because I firmly believed that he was not an obstacle.
We are on the same page.
Thank you,
Thank you.
Commissioner.
And then the issue of Ackerman then arose later. For example, paragraph 47, at page 292, another reference in paragraph 58, at page 296. Similani says, or claims there was no need to remove Ackerman as the issues were resolved with Pekoli.
Yes. Commissioners, it is correct that Advocate Similani came to my office to have Anton Ackerman removed. And I told him in no uncertain terms that this is not going to happen. I'm not going to remove Anton Ackerman. So I suppose what he sees as having been solved would have been the fact that I had then said Dr. Ramayite would attend those meetings so that the process can go on, because already we have had these inordinate delays on these matters. Again, as I said, I had to choose my battles and find a way of being technically flexible as to how I approach the matter. Because there's no point in being engaged in a battle and then actually then lose sight of the war. And the war, in this case, being protecting the independence of the prosecutors and going ahead with the prosecutions, with or without the support of other departments.
And then lastly, there's a claim by Mr. Simelane, which is set out in paragraph 53, at page 294, where he says quite clearly the NPA had its own investigative capacity. It reads, second, it is known that the NPA, through the PCLU, conducted investigations on its own, met and took statements from those it identified they needed a statement from. This was also confirmed by Ackerman in a meeting with members of the cluster in the presence of Advocate Bakuli and other members of the PCLU. Quite clearly, the NPA did have investigation capacity. So this is said in the context of the assertion that the PCLU did not have investigators at that time. What is your response to the claim that the PCLU clearly had its own investigative capacity?
Commissioners, this is clearly not correct. It has been stated time and time again that this matter, the Jucani matter, was ready for trial in 2004 because there was no need for investigations on this particular matter. So it didn't fall into the category of those matters that the NPA required investigators. So this is completely incorrect. Sorry.
And then lastly, and sorry to return you to the bugbear of Mr. Ackerman, but at paragraph 58, there's a claim that there's a suggestion being made that a request to remove Ackerman from playing an active role in the investigation and prosecution of TRC cases is tantamount to stopping prosecutions. He says it does not explain how this can be. Advocate Bakuli agreed with the request when he did not have to, if he was of the view that it stopped prosecutions. One can only conclude that he agreed because it did not affect the prosecutions. What's your response to that?
Commissioners, again, it's difficult to think, to really understand as to why you are having this. Because Ackerman was appointed as a special director with a specific mandate to deal with the post-TRC matters, investigation and prosecution of those matters. Now, if you take out the person who was appointed by the president via the proclamation, then you are effectively saying, no, perhaps, Mr. President, you made a mistake. You need to appoint somebody else because the person you appointed is not suitable for this. Because if you are insisting on removing him, what are you saying? Because he's the one with a direct legal responsibility and mandate to deal with the post-TRC prosecutions. So how could I have acquiesced in such machinations? This is completely wrong. Thank you, Commissioners.
And why would it have been of any business of the DG of Justice to come to you, specifically to come to you to say, get rid of him?
Well, just imagining why is because he was singing the same tune about the removal of Anton Ackerman. He agreed with the views of the other DGs. And actually something which, because he is a lawyer, he understands the law better than the DGs of the other clusters, of the other departments. That's why I couldn't understand as to why should he be betting, for this position, which was clear and untenable and clearly unlawful.
So you mentioned earlier in your evidence that you had been approached by Judge Zondo, who at the time was chairperson of the Zondo Commission into allegations of state capture. And just to let you know, if you didn't know that, the families of the Craddock Four, Nokutula Simalani, Ahmed Timal, Matthews Mavalani, Neil Agate, Imam Harun, and Hussein Hafaji did approach the Zondo Commission in the course of 2019, asking the Zondo Commission to investigate the issue of what they refer to as the capture of cases, of this category of cases by elements from outside the NPA. Can you indicate why Judge Zondo made contact with you and your response?
Commissioners, for the sake of the accuracy of the record, it was not Judge Zondo directly. These were the evidence leaders who required me to depose to an affidavit on my suspension and subsequent departure from the NPA. Of course, I was willing to cooperate. But this thing, I don't know how long it would take for it to go away, the pain, the suffering that I went through. But I indicated to the evidence leaders, because I had a consultation with the evidence leaders. I indicated that everything I've said everything on this matter, from the Chinwala Commission and the affidavits that I deposed to in the Nokutula Similane matter, and also in the Ahmed Timol matter, which involved the prosecution of Rodriguez. My affidavit were submitted in those cases. So it's a matter that has gone through our courts of law. And I didn't want to appear again and talking about all those things, because everything is on record. And that I have no objection to the Zondo Commission making use of my affidavits from the Chinwala Commission, the 2015 one on the Nokutula Similane matter, on the Rodriguez matter, that I have no objection to that. And I stand by those affidavits. That was my position. I didn't want to again be at the center of public discussions and debates. But again, this process is reopening that.
Thank you, Mr. Bikuli. Before we close your evidence in chief, is there anything that you wish to say to the Commission?
I would like to be short. I came here to be a truthful witness. I didn't come here to make accusations, to make allegations against anybody. I'm gone beyond taking issues personally, long time ago. I'm here to put facts on the table for proper consideration. And if, in the course of doing so, might appear that I'm making certain allegations, it's not me, it's the facts that speak for themselves. It's said that so many years down the line after the final report of the TRC, we're still talking about post-TRC prosecutions. It's painful for the survivors and the families of the victims that for them justice has not been done. You can say whatever you want to say. The lawyers representing government will say and put forward all the reasons as to why things never happened. They will point fingers at those who are actually responsible, who had a mandate to prosecute and did not prosecute. These are the issues that this commission will have to look at carefully and consider and make findings and recommendations flowing from everything that's going to be placed before this commission. And also, you know, I've got great respect and admiration for the late Comrade Dalauma. One of the things I learned from him when I worked with him as a special advisor and then being an official in the Department of Justice, it's the question of, which is in Section 10 of our Constitution, human dignity. No wonder it found expression into our Bill of Rights. This is what things should be about. Not about personal issues, who did what, who did not do what, but are we being true to Section 10? All of us sitting here, who are lawyers. You can put 10 lawyers in a room and perhaps give them same set of facts. But it's not improbable that you might get 10 different answers. It's not about that. It's about the truth. This is about making a determination as to who was as into who was responsible for the absence of prosecutions when the law was quite clear. I've got a respect for the late Dr. Zola Square, because he's the one who asked me to join the Department of Legal and Constitutional Affairs of the ANC in exile. And I got involved then in the discussions about post-apartheid South Africa. Yesterday, I made reference to the meetings that we had with the lawyers from South Africa, imagining a post-apartheid South Africa. And I'm happy that I participated in those things. I've got a better insight. And I had a better insight than the DGs of the cluster about the genesis of the Truth and Reconciliation Commission. Comrade Dala sent me to Chile in 1994 with Professor Midare Lemire, late, who happened to have been my lecturer at the University of Lesotho. I mentioned Justice Lex Mpati. I mentioned Ms. Tiny Maya, or Yoli Samaya, who was a member of the BLA, the practicing attorney, who went to Chile to study what happened in Chile, because we wanted to make sure that we will deal with these issues in a manner customized for our own situation, based on our own history. I'm grateful that Comrade Dala sent me on that trip in 1994, which formed the basis. And also, I'm not surprised that the Kalata family and the applicants in the Kalata matter relied heavily on my submissions on the question of the political interference in the work of the NPA. I understand why I have to spend this time here. And I'm prepared to come back for those who might want to cross-examine me on issues that I have said, on issues that I might not have said. I'm prepared for that. Thank you, Commissioners.
Mr. Pikuli, in closing, on behalf of the families, we'd like to thank you for your service to South Africa. We'd like to thank you for standing up to injustice. We'd like to thank you for resisting political interference and paying the price for that. We've set the best possible example for future NDPPs, for which the families thank you again. A debt of gratitude is owed to you. Thank you. No further questions.
Thank you, Mr. Vani. Mr. Prophet, or Ms. Rantu?
Thank you,
Any
Commissioners.
clarificatory questions?
There will be, we will do our best to select a few commissioners. It's almost the evening. Good afternoon, Advocate Pikoli.
Good afternoon.
On behalf of SAPS, just some few clarification questions.
On behalf of SAPS.
SAPS, indeed. And then you spoke about Chapter 3 of the Constitution. You'd recall you testified about the need for collaboration among the state entities, the cooperation, so to speak.
That is correct.
Now, specifically relating to ITT, I just want to find out if there was any working document.
In specific relation to?
The ITT thing, the formation of the ITT.
The ATT.
Interdepartmental trustee.
Interdepartmental.
ITT.
Yes. Yes, there is reference in the panels.
Yes, there is.
Yes.
What I wanted to understand.
And it's documented.
Okay, thank you, Advocate Pikoli. Perhaps to be specific, the working of the NPA, and when I say NPA, that includes PCLU with the police. Remember you spoke about the lack of cooperation on the part of the SAPS in terms of assisting with investigation.
Yes, I did.
What we would like to find out is, what was the working arrangement? Was there any document that was formulated to assist in terms of knowing as to how you would work, that collaboration? And we asked that question specifically because you did testify yesterday that investigative powers, in terms of the Constitution, like with the SAPS. So what we're trying to understand is that at that time, when it is alleged or when reportedly there was a lack of cooperation by the SAPS, allegedly their failure to provide the necessary assistance insofar as investigation is concerned. So we are trying to establish, was there any document or memorandum of agreement for that matter that would have aided that impasse? In other words, to assist in terms of knowing when to come in and not when to come in as SAPS.
Thank you. Commissioners, let me start with a small clarification that when this matter of the establishment of this commission came up, I was the special advisor to the Minister of Police, Minister Senzo Mchunu, and continued in that position with the Minister of Finance, Kachalia. I immediately informed both of them because it's a matter which also fell on the lap of SAPS, that I'm not going to be involved in any discussions around these issues of consultations, because I know that to a large extent some of these issues will affect me. But coming directly to the question as posed, there is ample evidence that shows, starting from what Anton Akamen said about SAPS not cooperating as expected to the TSO, not providing investigators. And the question of SAPS being responsible for investigations is a matter also which was properly traversed in the first Khampepe Commission. The question of a single national police service, as outlined in the Constitution, the chapter 11 of the Constitution. And there was no problem with establishing the DSO and it being given special policing powers in terms of investigations. These are matters that were openly discussed in the first Khampepe Commission. And there's ample evidence that shows that there was lack of cooperation between the NPA and the police in terms of availing investigators, including problems within the NPA itself, where we would have expected the TSO to avail investigators. There's evidence to that effect. It's here in all the banks. I'm sure we can be able to specifically talk to that issue.
Okay, so what I can understand from Advocate Piccoli is that there wasn't any memorandum of agreement between the DSO, let's say NPA at that time, with the SAPS insofar as what to do and who decide, and the do's in terms of what and when and who. And that's why, and perhaps if I may just assist Advocate Piccoli, we're saying that against the testimony that you gave and the one that was also given by Advocate Nguga in terms of the tension that was between the SAPS and the particularly DSO at the time. And that's why now we're trying to understand against that which the Constitution obligated the two entities to collaborate, whether there was any working document. And that's what we wanted to find out, that was it just a matter of NPA hoping that SAPS would cooperate, on the other side, SAPS also hoping that NPA would cooperate, and that's why we're trying to understand, was there something that was kind of formalized in terms of regulating the operations of the two state organs?
Thank you. A short answer is that there was no memorandum of understanding.
Yes. Yes.
Thank you, Advocate
Yes.
Kule. And then there is also an issue of the removal of dockets. That were taken to Fisachi. I think it's been put like Fisachi Street somewhere, or some building, but your testimony was that your predecessor decided that some dockets, I would assume they involved the ANC 37, were taken back, or were actually taken from NPA to the SAPS. Is that how we understood your testimony? Where you were present? I think your testimony was that you were also present when that transfer took place, and that there was also no audit conducted.
Thank you.
Yes.
Commissioners, first I want to eliminate the question of Fisachi Street. Because where I was when the dockets were removed from the TPP's office, and the TPP's office is not in Fisachi Street. I was present when the dockets were removed, and they were removed from the offices of the TPP Pretoria, which I think are in Church Street.
Do you remember who received them on the part of the SAPS?
I think Mr. Ncuka made it clear that, okay, let me just talk about my own recollection, because I want to believe that Commissioner Tim Williams would have been there when these dockets were removed from the offices of the Director of Public Prosecutions, Pretoria. Obviously, there were other police officials who were there. I won't be able to remember all of them. And I can't even say, though, you know, I might assume that he was there because he was in charge of the legal services, Commissioner Flip Jacobs. But I'm speaking under correction on this.
Perhaps also to be clear, you were there in your capacity as the then DG of Justice.
That is correct.
Okay. And the issue of the tactical approach that you spoke to when you were asked about the meeting that took place as the then Minister Square's house, you remember that? And the testimony that you gave was that I think there was a level of flexibility in terms of where to attend meetings and what time of the day. So for you, it wasn't really difficult. That's how we understood you.
Yes, to be accurate, I talked about a term which I just coined on my own, about tactical flexibility. That's what I said when I was led in evidence.
So what we are trying just to clarify is that that meant you really did not have a difficulty with the meeting being held at the minister's house in a way, when you said you adopted that. We are mindful that you said that was subject to you maintaining your independence.
Yes,
Yes.
You'll be correct.
Yes.
That is correct.
And then there was also an issue of the policy statement that, as you explained, that for all intent and purposes, everybody that formed part of the DG's forum, or what, let's say that the task teams or interdepartmental task teams that were formed under the JCPS,
Yes.
there was a good intention to give effect to the policy statement of President Thabo Mbeki. You recall that you did say that it was intended to serve good. What we also gathered was that the lack of cooperation was not only from the SAPS side, but then, as you said, I think that's when you were speaking, or you're talking about the presence of Reverend Jucani, being the DG at the time in the office of the President. You'd recall that you said there was no problem with that because there was a problem of lack of cooperation by a lot of departments. You remember?
Well, perhaps to clarify what you might have misunderstood. The primary role player was the SAPS in terms of availing investigators to assist. The DSO also had an obligation to provide investigators to assist the PCLU. And this was not forthcoming from both the SAPS and the DSO. And of course, when it came to the police, the main issue seemed to have revolved around, perhaps two main issues, to have revolved around the participation of Anton Ackerman in the process, which made them not want to cooperate. And two, there's so much, there's often repeated lie. I'm sorry to use such strong language. That it was the intention of the NPA all along that as soon as there's a prosecution against the generals, that the NPA is going to pursue investigations and prosecutions of ANC. And this was coming from SAPS. And this position was accepted by other departments, including the Department of Justice and the NIA. That's the crux of my submission.
It's just for clarity, Advocate Piccoli. Another thing that we're also trying to understand is that your interaction with the late Commissioner Silebi was more at the head of offices level, isn't it? Your counterpart, so to speak. Meaning the National Commissioner was your equivalent, but obviously responsible for the police at the time.
During which period with me in office?
Either at the time when you were the DG or when you became the NDPP?
No, that would be a wrong understanding.
Okay.
When I was DG of Justice, I regarded myself as, in the same position. Because we're DGs answerable to ministers. And yesterday I did try to explain the difference, not out of any superiority to think that the NDPP is above everybody else, but the fact that the Constitution gives the responsibility of determining the prosecution policy to the NDPP. Now, there's no DG in government who has got that responsibility. So, obviously, that policy will be in accordance with the constitutionally guaranteed independence of the NPA. And then the fact that it says that, but this must be with the concurrence of the minister. Then it puts the position of the DGs, including the National Commissioner, slightly different from the position occupied by the National Director of Public Prosecutions. So, in terms of role playing, or in terms of executing the tasks required, would have been different.
Okay. Perhaps if I may just make myself even clearer. Yesterday you gave testimony in relation to the role played by the executive authorities. Those are my cabinet ministers, let's say the ministers. And what I wanted to understand when I actually tried to establish that your relations with the late Commissioner Sleeby was more of your counterpart, meaning your colleague who's responsible for another department, say SAPS. And I'm mindful that as NPA, of course, you were independent, but you were the head of NPA as the NDPP, isn't it?
Yes, purely on the basis that I also wanted to give peace and stability a chance. That's why from the outset, I said, when I was the DG, I was fully committed to ensuring that the statement of the president, is given effect to when I was DG.
Yes.
My position didn't change
Okay.
when I was NTPP.
Thank you. What I'm trying to establish further is whether your interaction did not involve the Minister of Safety and Security at the time. Because the lack of cooperation from your evidence was more coming from SAPS. And that is running through even from the evidence of Advocate Ackerman, Advocate Muller, to say it was more SAPS.
Ms. Rantu, isn't that a question ripe for cross-examination?
I will do so, Commissioner,
Yes.
if it's so. Thank you for that. I will defer the question. Thank you.
Thank you.
Perhaps just one last thing, the interaction with other stakeholders. We also seek clarity as to whether you also had interaction with the DG of National Intelligence Agency at the time, NIA, in terms of this lack of cooperation. Did you also have that with NIA as well?
That is correct, Commissioners.
Okay. Thank you, Commissioners. I think
Thank you, Ms.
will
Ranto.
defer them to cross-examination.
Thank you.
Thank you very much.
Ms. Sakai?
Good afternoon, Commissioners. Thank you, Advocate Goli. We don't have any clarification questions today.
Thank you, Ms.
Thank you.
Sakai. Mr. Tabata?
Thank you, Commissioner. We have no clarification.
Thank you. Ms. Rokotso?
Thank you, Commissioner. I think we just have one question, and I'm sort of piggybacking it off of the question by Ms. Ranto. Mr. Bikoli, this goes back to the time when the dockets were being collected at the DPP's office, and you were there, but at the time you were the DG. So now the interaction was clearly between the SAPS and the NPA. So now the question that we lacked clarity on was, what role were you there to play as the DG while dockets are being collected by SAPS? You never said that when you were leading your evidence.
Thanks, sir. Commissioners, I think I did talk about this thing. That, my presence there was as a co-chair of the JCPS cluster of DGs. And that this is a matter that was being considered by the JCPS cluster, given the fact that it included issues of investigations and prosecutions, therefore cannot be divorced from the criminal justice chain. That I think I did say that quite often yesterday. That's what made me to be there when the dockets were taken from the office of the DPP to SAPS.
Thank you.
Thank you, Ms. Rokotso. Mr. Siminya, any clarificatory questions?
Just a small area, Chairperson, if I may. Advocate, again, good afternoon to you.
Good afternoon, sir.
Please do not read any of the questions I put to you as a challenge to any aspect of your evidence. I just want to take us back to 2003 and look at the address by the then President to Parliament. it would seem to me that there was concern about two categories of people. The one would have been those who, on poor advice, did not participate in the TRC process, right?
That is correct, Commissioners.
And the other category would have been people who thought, for good or bad reasons, they won't be found out and caught and prosecuted. Am I right?
That is correct again, Commissioners.
The reading of that address also appears to raise a concern that the post-TRC outcomes have left other matters fragile. Am I right?
Have left other matters what?
Fragile, such as
Fragile.
the reconciliation that that process was intended to achieve.
Yes, that's correct, Commissioners.
And the plea in that area was that perhaps there could be creative methods by which to accommodate those concerns. Am I right?
That was my understanding. That's correct, Commissioners.
And the creation of the amnesty task team, which you correctly say is a misnomer, was intended to see if there weren't any creative ways in which that can be done, right?
That is correct, Commissioners. Except that, talking of creative ways, it conjures something else in my imagination as we're trying to. But the truth of the matter is that we were to find perhaps new ways of trying to deal with this matter without any precedent. Yes, in that sense, we
Yes.
were to be creative and be imaginative.
Not to find solutions. I
Yes.
mean, there were various areas in which efforts were directed but would meet a cul-de-sac, be it certain legislative instruments that can trigger a resolution of that problem, for instance, right?
That is correct, Commissioners.
And there would be difficulties, as I understood your evidence, such as the fact what underlying statutory premise would exist for those opportunities, correct?
Can you come again?
You would look at various possible solutions, including what statutory premise would help achieve those solutions. Am I right?
That is correct, Commissioners.
Still hitting a cul-de-sac because there was no such instrument to facilitate the legal basis for that type of solution. Am I right?
Except that it was thought prudent to look at the prosecution policy with the view of accommodating this special category, I'm saying special category of cases, which might not have been within the contemplation of those who drafted the first prosecution policy, because the reality then demanded that there be consideration to this new or to this new category.
Yes.
That's the nearest in terms of legislation, but it was policy. Yes.
And as you correctly say, or at least you said in our evidence in chief, you did have concerns about the prosecution policy. But in furtherance or in amelioration of the difficulties you had with it, at least the prosecutorial independence was safe. Am I right?
That is correct, Commissioners.
And that also ended up with the prosecutorial policy being set aside. Am I right?
No, the policy was not set aside via the
Well,
amendments. This was an addition to accommodate a special category of cases. So the amended policy did not replace or displace the existing prosecution policy. Yesterday, I spoke of supplementing and complementing it.
Yeah, perhaps I did not express myself too well, but the point I'm making is all of these efforts are done in public. There's nothing clandestine about it. Am I right?
That is correct.
That table before Parliament for its consideration, right?
That is correct.
Cabinet as well.
That is correct.
All of that in an attempt to deal with what you call this special category.
That is correct.
And it may be open for argument to others to say these were efforts intended to widen the ambit of opportunities to reconcile the reconciliation effort. Am I right?
That is correct, Commissioners.
As opposed to being efforts at stopping the work of the NPA. Am I right?
You are right. It could not have been an attempt to stop the work of the NPA.
Neither being an effort to stop the investigation of TRC cases that required investigation. Am I right?
It could never have been the intention. That's correct.
Yes. Now, if we talk about the Section 105, capital A of the Criminal Procedure Act, that was good law before the address by the then president. Am I right?
It was existing law.
Yeah. So the facility to have a process by which plea and sentence agreements could be concluded was still good law. Am I right?
It was law that was in existence. That is correct.
And even post the address by the president, it remained still good law to have that as a tool open to the NPA.
That is correct, Commissioners.
In fact, as a matter of fact, the General van der Merwe, Commissioner van der Merwe, and the minister, together with the other three, were prosecuted strictly in terms of that facility and power the NPA had.
That is correct, although I was not really in favor of that. Yeah.
Yeah.
That is correct.
What I mean is, even when you were there, the readiness of those matters to be concluded in that manner was still open.
That is correct.
Yeah. Okay. Lastly, the fact is that no beneficiary came out of a process by which the prosecutorial policy, as amended, was derived. Am I right? Nobody got the benefit of an amnesty through those efforts. Am I right?
Not when I was there.
Okay. That would be the end of the questions I have for you.
Thank you, Mr. Siminya.
Sorry.
Sorry, Chair, I'm told somebody's hand was up.
Good afternoon. It would be my hand, Chair.
I can't see you.
I can't see you too.
Oh, I can't see you.
Can
Yes,
you
thank
now see me?
Yes.
I can see you on the screen. Yes.
Thank you so much.
Yes, Ms. Njoko. Where are you sitting?
Yes. Chair, I unfortunately
Oh,
had
you
a
are
leave to
on
appeal
virtual.
in Pretoria.
Okay.
Yes, I am virtual.
Yes, Ms.
And I
Njoko.
must thank the Secretariat for organizing for me to join. Chairperson, in light of the time constraints before the Commission right now, and of course being mindful that I myself included, some of the people there also keep Sabbath, we as the NPA propose that we will ask our clarification questions together with our cross-examination, because there are certain aspects that we would want to canvass with this particular witness in relation to dates and particular persons that he has mentioned in relation to the NPA. And therefore, we think that might be the most prudent manner in which we can, in fact, deal with this.
Yes. Yes, thank you, Ms. Njoko. I think
Thank you.
that will be highly advisable.
Thank you, Chairperson.
Am I missing anyone who's appearing virtually?
There is no one else on the platform. It was my senior, but he had to fall off because, of course, Sabbath is starting soon, and so he had to drive home.
Thank you, Ms. Ntloko. Mr. Vani?
Thank you.
Thank you, Chair. Just two small matters by way of re-exam. Mr. Pikoli, in relation to the question put to you by my learned friend for the South African Police Service as to whether there had been a memorandum of understanding struck between SAPS and the NPA in relation to the TRC cases. As Special Advisor to the Police Minister, you would be aware that Section 205, Paragraph 3 of the Constitution.
Section 205?
Yeah, sub 3.
Sub 3.
Yeah.
Yes.
Which essentially says that amongst the objects of the police service, one of them is to investigate crime.
That is correct.
Yes. So why would you need an MOU if the SAPS is already constitutionally mandated to investigate crime and is indeed obliged to investigate crime?
Well, that's why I say that there was no memorandum of understanding that I can think of. And I'm saying this also conscious of the responsibility of SAPS. And I did talk about the question of SAPS having a constitutional mandate to investigate crime.
So that there should be no need for a special document or MOU to investigate these crimes?
Especially given the fact that we're dealing with one criminal justice value chain.
Yes, and of course we're dealing with crimes such as murders and kidnappings and the like.
That is correct.
And my learned friend for the evidence leaders, he, when talking about the amendments to the prosecution policy, he noted that one of the objectives was to promote national reconciliation. Now, given that in your evidence you've conceded that in the preparation of that policy, victims and families and their communities were not consulted, and given further that Part C of the policy provided a number of additional criteria on which not to prosecute, in other words, avenues for perpetrators to escape justice. In the light of those two factors, could it really be said that the prosecution policy in reality served to promote national reconciliation?
Yes, because, thank you, Commissioners. Yes. Because there's reference also to perhaps coming up with matters which might not have been put before the TRC because of the absence of other people who, for whatever reason, did not appear before the TRC, which created then, the fragile peace which we were enjoying at the time. Therefore, we needed a process that would have put everything on the table to be able to deal perhaps with those outstanding matters. Because clearly, in the view of the President, he felt that the TRC, though it might have, what it did, submit its final report, but there were still some matters which did not really address the issues of peace and stability and all that. Hence, the need to accommodate those issues within the framework of the law. And then, of course, like I said yesterday, as far as the NPA, was concerned, it did not take away the discretion on the part of the NPA to prosecute any matter which it would have deemed fit and proper under the circumstances.
Yes, but you accept from the perspective of the families, families of victims of these gross human rights violations, and indeed it's one of the grounds they put up before the High Court, was that the amendments to the prosecution policy undermined the objectives of the Truth and Reconciliation Commission, including the objective of reconciliation, amongst them for the reasons that I've given, but you accept that that's their perspective?
Yes, I do say so. It was, and they are right in terms of the view that they had formulated. I have no problems with that.
No further questions, Chairperson.
Thank you, Mr. Vani. I thought you were pushing it hard there, Mr. Vani. But as you say, that's their perception.
Indeed.
Yes. Advocate Piccoli, we offer our profound gratitude for you having availed yourself to come and give evidence before this commission, some of which has had the effect of re-traumatizing you. But as you know, we must receive this evidence in the execution of our mandate as set out in our terms of reference. As you have heard yourself, there will be applications to cross-examine you, so you must remain available to submit yourself to cross-examination. The date and time will be made known to you in due course. You are excused for now as a witness.
Thank you, Chairperson, and I will submit myself to any cross-examination which may be required.
Thank you.
Thank you, Chair.
These proceedings are adjourned. These proceedings are adjourned.
Chairperson, might I just point out that we have a High Court matter on Monday and Tuesday, and those would be non-DAs for the proceedings of this commission.
Yes. What is the date on Wednesday, Advocate Smith?
It must be 18, 16, 17
Yes.
is Monday, Tuesday.
These proceedings are adjourned until the 18th of March at 10 o'clock.
As the Commission, please.